Calf for your kids?
Yeah.
Mr. Chairman, we are live streaming now.
Thank you. Yep. Much as I'd love to appreciate or to continue that wonderful conversation.
Jared, this is afternoon. This is Beef Chain.
Ah, gotcha. Now I'm tracking. Okay. Looks like we're waiting on a couple of our liaisons. Oh wow. Speak of them and they just roll right on in.
Let's see.
All right.
Quorum. I think we don't have. We do. All right. I think we're a quorum.
We are there. We're beyond quorum because we have an extra senator now.
We're post quorum.
All right.
I've been on and off, but I'm going to have to leave again. SBC starts in 10 minutes and I'll do it. It's going to be a short one. Then I'll be back on.
Okay, great, Ogden. Thanks.
Just leave your proxy with Representative Lindholm. I'm sure he'll take good care of it.
Did he not tell you at the start of the meeting he had it? I didn't use my chairman to excuse myself. I used Tyler and I told him he had my proxy.
We haven't even voted on anything. We were gonna vote on something and somebody got cold feet on that one vote.
It's called the deliberative process. Unhurried discussion, Representative Lindholm.
Your only chance is to wait till January. That's it.
Talks in a committee meeting or a slippery slope I am never even going to get near the edge of.
All right, we are still on SIM card identity protection. We have public comment and possible legislation. I know we have, oh, yep, just looking for you there, Mr. Allen. Mr. Allen, public comment, please. Yeah, introduce yourself again for the record and then please proceed.
Yes, Christopher Allen, Blockchain Commons, based in Wyoming, although I live in California currently. I wanted to kind of give the select committee a little bit of perspective from the security professional side of things, because I think there's an entire aspect of this that you have not kind of looked into, although I think Co-Chairman Rothfuss sort of mentioned it in passing, which is that the fault is not precisely on the companies, the telephone companies. I am not a lobbyist for them. I don't support some of their lack of improvement in this area, but the bottom line is that SMS, as what do we call an OBB, OOB, out of band authentication mechanism, was never designed for that. There is no, security design for that. There is no incentive or payment design to the parties to make that more secure, et cetera. In 2015, a number of my colleagues who work with a lot of security firms testified before the National Institute of Standards, which is the US body that defines a lot of the standards for cryptography and security. And in their 2016 release, they basically said that out of band authentication using SMS should be deprecated, or specifically they said is deprecated. They said it should not be done in their 2016 guidance. Unfortunately, the international GSM groups, other lobbyists, et cetera, in 27 got them to remove that deprecation. So in the 2017 version of it, it was no longer mentioned in there. So I do consider the phone industry somewhat responsible for this continued abuse of SMS-based 2FA, second factor authentication, in the fact that they, could have had a pass because nobody would be using it in 2016, and so they have some responsibility for bringing it back. But the bottom line is it's not them, it's the parties that demand it. There are still exchanges that are, Bitcoin exchanges that are using 2FA only through SMS or defaulting to that and only allowing it to be added on later. There are still major internet companies that only allow that. Even Twitter, which recently added some other things you had to start with and default to SMS-based 2FA until, of course, their chairman of the board got hacked through his SMS. So now you'll notice you can turn that off. You couldn't for a while. They are the ones that really should have the responsibility. No, a chief security officer should be recommending for 2FA any SMS mechanism. And I consider it kind of gross negligence that a number of these companies are still using it. So specifically to Wyoming, what can Wyoming do about this? One of the things you can do is to say that, your kind of rough equivalent of National Institute of Standards is your banking commission. Your banking commission should, has a lot of knowledge now about security and blockchains, and they have a responsibility to manage the banks. They should begin the process of understanding who's still using 2FA, deprecating that with those parties, recommending some kind of deadlines to get off, and an absolute, you cannot be a bank using 2FA that is registered in the state of Wyoming, after such and such a date. Start the process rolling where they can basically set the standard that banks cannot use SMS 2FA. They can use it. I'm not saying there isn't a role for SMS in certain kinds of things, but not as just the second factor. Maybe part of it as a multi-factor, maybe part of it as a whole notification process, allow some innovation there, but not as a sole factor for authentication. Mm-hmm. So I would say that would be a first step that you guys could work toward, that you have talented people who kind of understand the problem, in your own group. There are other areas that either Wyoming regulates or pays money to. So for instance, you have a deal with Google for Google's Gov software package. You should probably get them to turn off 2FA. They support other forms of 2FA or MFA, but make it official, turn it off. Demand that other parties that do business with Wyoming do not use SMS 2FA. I think that will send a strong signal that it's time to deprecate all of this. And if you want to add liability and all those other kinds of stuff, Wyoming is a great state, but it's also a small state. But at least sending the signal, it's time, and it's don't blame it all on the telephone companies. They get 10% of the blame, in my kind of personal opinion. It's really the people who said, oh, well, we're going to take this thing that wasn't intended for authentication and use it for it anyhow. And that's where the real blame is. I'm open to questions. Thank you.
Senator Rothfuss.
Thanks, Mr. Chairman. Yeah, and Christopher, thanks for that. I think that that's more of the track that's probably appropriate. We'll have to give some thought to where and how we could do that, either statutorily or elsewhere. But I do agree that we have to be kind of thoughtful about who is complicit and who can make the changes that fix the problem. If we're relying on the security of a technology that was never intended to be relied upon for security, then that's not necessarily the fault of those that are hosting it. So good points on that. And I appreciate it. We'll give some thought to maybe how we could carry that out. And I think there are some other just best practices that, maybe even stating something like, if you're storing passwords, for example, you really never should be doing that if the password protects anything. You shouldn't be storing the password itself. Only a hash of the password, obviously, and things like that. I don't know how you get at a best practices for a state where if you're not doing these things, you might have liability. But if you are doing these things, that's certainly going to limit it. Those are the kinds of things, maybe we can think through. Thank you, Mr. Chairman.
Mr. Allen.
Yeah, just a minor comment. Best practices change and evolve. I would say today a hash isn't good enough. You have to do something like script or one of these things that hashes thousands of times. As I described in my other testimony, passwords, because of modern computers, are even hashed, are becoming less and less secure every year. For about $25 and an AWS instance search, I can search through billions of possible hashes, such that a 12 character, 14 character password can be broken, even though it's hashed, for about $25. So anything that's worth more than $25 to break, go buy an expensive NVIDIA card or rent an AWS instance. So that's going to change year to year. I do think they should have best practices. I think they should disclose what their best practices are, and then let other parties basically go, wow, you guys are really out of date. Let's not do business with you. Thank you.
Representative Lindholm.
Yeah, thank you, Mr. Chairman. Not so much a question, appreciation for Mr. Allen staying tough with us, but I did want to mention SMS 2FA for those folks listening in that haven't been around that before. That's when an app, a third-party app or something like that, you sign up for an account and they ask for your cell phone number so they can do two-factor authentication. And every time you log in over a time period, some are 30 days, some is every time, they send you a text message with a code, and you type that code into in with your login as a two-factor authentication. That works really good until somebody does a SIM swap, and then they have full access to all your accounts, and that's banking. That's the list goes on. And so that's where Mr. Allen was coming from, where he's talking about SMS 2FA. Correct, Mr. Allen?
That is correct.
All right.
Well, Mr. Allen, again, thank you, and always insightful. I took note of your comments on Google and the state system, and so I will be following up from here to look into that as well. So I do appreciate you at least bringing that to our attention.
Thank you.
Okay. With that, do we have any other public comment on SIM cards? I don't. Mary Beth, do we have anyone else?
Mr. Chairman, we do not.
Thank you. Okay. With that, committee, what is your pleasure? We have a bill in front of us. We have several competing concepts as well. We have another meeting. If you want something worked up, we should probably get that worked up. Need a motion for that. If you want to run this bill and work it, then let's maybe move it into the hopper and start getting some of those ideas formulated. If you just want this bill, then let's move this bill. Representative Lindholm.
Mr. Chairman, I'd like to move the bill.
Okay. So moved.
Second.
And seconded by Ms. Long. All right. Discussion on the bill. Representative Lindholm.
Thank you, Mr. Chairman. I think when it comes down to this specific piece of legislation, I mean, we've heard some concerns from industry that this might have a negative impact on them. And I think, yeah, I mean, there definitely might be some merit in that statement. And I definitely have concerns there. I mean, we're all about trying to attract business to the state of Wyoming, expand broadband access, expand our wireless availability. I don't have cell phone service in my house. 26 Windy Way, if somebody wants to fix that. But the reality is, how are we going to get there without carrying on the conversation? And that's like my biggest concern. How do we get to that solution? And this is a relatively new concept, so it's not like we've driven down this track 37 different times. But I was heartened when we did hear from a national organization that came out here. It gives me heart to know that they know Wyoming's for real, and this committee likes to get things done. So I'm hopeful that if we move this bill forward with or without amendments, and we see it at the next meeting, that maybe they'll come forward with some solutions, with some ideas that we can apply in the bill. Because the reality is, it is a big deal. It is theft. This is a consumer protection aspect for our constituents here in the state of Wyoming, and we have an obligation to run that ball. We have an obligation to protect them. Now, granted, we got to be smart about it, and we got to make sure that we don't inherently ruin an industry because we went a little too far. So that's my hope, is that us moving this ball down the field will bring some more folks to the table, hopefully, and let some ideas come out.
Representative Yin.
Thank you, Mr. Chairman. I'll be voting for this bill if we move forward with it. I think it's pretty clear from the testimony we heard from our local providers is that they are doing reasonable things to protect our security. And I don't think our concern is necessarily with the ones that are doing reasonable things with security. Our concern is with the ones that are not, right? And so that's the bad behavior we need to rein in. And especially when it comes to the big providers, they have the funds. They're not going to be disincentivized for doing business in Wyoming when they could just do it. It's a real struggle to understand why they aren't doing it already. So if this at the very least brings them to the table so we can keep moving this bill forward, then I'm all for it. Thank you, Mr. Chairman.
Thank you. Senator Rothfuss.
Thanks, Mr. Chairman. My concern, I have a few with this bill. The first is that this bill, basically as currently drafted, did already start through the legislative process and failed in committee because it didn't accomplish the objectives. So I agree with the objectives, but I guess I'm reticent to move the same piece of legislation forward when, as a task force, we usually just fix those things. And I would like to fix it. If we want to move this and take another run at it, let's put together a piece of legislation that does the job, addresses the concerns that were raised, clearly makes things better, and move that forward. And once again, if we can't come to that and we want to move it along, I think we could look to it. We could put together a small working group, perhaps Representative Lindholm, Representative Yin, anybody else, Ms. Long, to fix it. I'd much rather do that than just pass it in its current form. I don't have any confidence in its current form, to be honest, but I'm fully on board with the concept.
Representative Lindholm, who was not present at the committee meeting at the time the bill died.
Yeah, thank you, Mr. Chairman. I think that's kind of goes to it, right? This was carried by a very knowledgeable individual in regards to this issue, but I don't know that he was completely prepared for the onslaught of half the lobbying force in the Capitol showing up, and I don't think my committee was prepared for that. And so, even if we move this piece of legislation forward, I think it'll be this committee and the chairman of this committee, who's, now that we know what to expect, I think it's imperative that we move forward with that in mind. You know, it wasn't intended that a bill was going to be worked really hard and new ideas were going to come forward during that committee meeting. Nobody really knew what to expect. I'm not saying that the bill is perfect. I'm not saying it's inherently flawed because of one vote that happened where several members of the committee were missing, and it was a new idea that had been brought forward and never talked about before, is what I'm saying. If the chairman want to move forward with a working group, I fully respect that. I'm not going to withdraw my motion, though. We're going to vote on this thing.
I share Senator Rothfuss's reservations about the bill as drafted, and I wasn't present in the meeting, so I don't know exactly what the testimony was. And maybe it's simply just what you're saying, Representative Lindholm, that there's a pretty big policy choice, and the legislature was, I suppose, kind of hit by surprise with its own bill. Didn't know what it was really stepping into. Maybe that's part of it, and maybe there are some issues with the legislation we can fix. My position would be, if we're gonna, I don't have a problem voting on it, because conceptually I support the concept and the fix. It's just, if I wasn't present in the meeting, and if we can figure out what the testimony was, if there are some holes that we can patch up between now and December and look at the final version of the bill again, I'd feel more comfortable as your chairman, who's going to take that bill and shepherd it through the process. And I'd like to know that we've got, if we had issues, we had them fixed, so that I don't walk into a committee meeting and the testimony from the industry is going to be, well, this is the same bill we saw 1 year ago, and here were the problems there, and the legislature, you guys didn't even address the problems. And again, I don't know if there necessarily is a big list of them. Those are just my thoughts. And I think Representative Lindholm would be a perfect person to spearhead that committee. Representative Greer.
Yeah, thank you, Mr. Chairman. So I just always have to have simple thoughts on things. But Wyoming's a small state, small population. It's hard to garner competition. And my concern, and the concern I had last time this came around, was what happens if we put up too many regulatory barriers here, too many things that make it difficult to do business in Wyoming. And so if we look at this again, or look at this deeper, how do we do this? Because it isn't just a state issue. It's broader than that. And that's my biggest problem with this.
Great point, Representative Greer. Representative Lindholm.
Yeah, thank you, Mr. Chairman. I was just curious, that if we have a vote, that's not final vote for approval, is that correct?
No, Mr. Chairman, that would be, that's the concern I have. This is the vote on the bill. You moved the bill.
Well, yeah, I thought we were moving it. I guess, pardon me, Mr. Chairman, I thought we were moving it so that we could continue working it at the next meeting. If that is the case, then I'll withdraw my motion, and old blockchain will go without another one.
No, Mr. Chairman, you can, if what you want is to work on this for the next committee and move it forward, like you just said, I think that's a very different and much more comforting motion. But if you want to pass this bill in its current form, that's where I would have concern.
Oh, gotcha. My intent, Mr. Chairman, was to move it forward to the next committee meeting. We had talked about working this during the next committee meeting, so that was what I thought we were doing. My bad.
It's a lot better motion.
That's the motion I heard originally.
Is it? I did not. I'm sorry. That's my bad then, Mr. Representative Lindholm, if that's the case.
Representative Yin is the second. Is that the motion you heard?
I believe Ms. Long was the announced second, actually.
Oh, Ms. Long, is that the motion you heard?
Mr. Chairman, I thought we were moving the actual bill. So perhaps to clarify, we should withdraw the motion. I'd be happy to withdraw the second and move a new motion that would clarify. Would the bringer of the motion be willing to do that?
Representative Lindholm, why don't you just amend or clarify your motion for us?
Mr. Chairman, the intent of my motion was to move the bill forward to the next meeting so that we can continue working it, and everybody can develop amendments and whatnot.
Okay.
Gotcha.
Ms. Long, are you still?
Second.
Second?
Yes, that's
Okay.
fine. Yes.
All right. Further discussion on the motion. Senator Rothfuss.
Thanks, Mr. Chairman. I just went from an opponent to a supporter of the motion with that clarification. Thank you. Mr. Chairman, just a couple of comments on things that I've heard as being concerns. One of them is the way we've structured this legislation. We actually have it as an unlawful, deceptive trade practice is the way it's structured. In the first discussion we had during this interim, there was discussion of just going with liability instead of this, that if you don't use best practices, then you will be liable for damages. And it was Senator Nethercott that actually suggested that we have elevated damages so that there's a punitive side of things. But to me, that structure of use appropriate practices or you will receive the liability for the bad outcomes is probably more appropriate than calling it a deceptive trade practice, because I don't know that it is a deceptive trade practice and it sort of fits awkwardly in here. I'd be curious to know what the rest of the committee thinks about that change in approach as a discussion point. And Representative Lindholm, do you have any thoughts on kind of switching it out of deceptive trade practices and just having a best practices standard more similar to what Mr. Allen said, you shall use best practices, or liability?
Representative Lindholm.
Thank you, Mr. Chairman. I would be supportive of that, but I think in order to do so, we would have to have an area of existing law or regulation to cite as far as what those best practices would be. And then that creates the concern, is that a frequently changing standard? And do we need to, can we point at a regulation to use some of the testimony we got holistically? Or do we have to be specific? I always tend to want to be specific, because not knowing what future regulations might be, I don't know.
Mr. Chairman, Representative Lindholm, back on Digital Information Privacy Task Force years ago, I feel like we put together legislation like this regarding personally identifiable information protection, and we put together some phrasing which was discussing industry best practices without necessarily pointing to a specific standard, because we recognized it would change. Do you recall that? Is that how we did that, or did we do it differently? Maybe we can look into it.
Mr. Chairman? Yeah, I thought we cited.
Did we?
I thought we did, because we had a bunch of debate, Mr. Chairman, surrounding what to point at, and we had advocates and opponents, both in regards to PII on education levels, in regards to the education field. And I thought I remembered we pointed somewhere in regards to education statutes.
And Mr. Chairman, Representative, I thought we said something along the lines of nationally recognized standards and best practices. We were basically trying to hint at NIST and ISO, I thought. And I don't know whether we ended up doing it that way, but we didn't explicitly call out NIST, ISO, or anyone else, because there are multiple entities. But we basically would want to get at those nationally recognized or internationally recognized industry best practices for protection of data, data storage, password, privacy, all those kinds of things. Maybe we could put together a paragraph or ask staff to put together a paragraph that basically tries to capture that. And we might have done it before, but I'd have to look it up. Mr. Chairman, I'd ask Mr. Kaufman what his thoughts are on the civil liability and how he would suggest, if he's thinking about it from a statutory standpoint, or Representative Greer as an attorney, how that might be constructed so that it would be potentially useful.
Okay, Mr. Kaufman.
Mr. Chairman, that's a great question. I don't know at this point in time that I have any real great epiphanies about this. I think it's a tough area. I mean, I've only admittedly read a few cases on the civil liability, and it's all over the board, and it can be tricky to enforce. So I think, I do like the idea, for what it's worth, off topic, of pushing the bill back, because I think for us to take a good stab at putting some language that aids in the civil liability portion, we're going to have to really hone that in tightly, Mr. Chairman.
Representative Greer.
Yeah, so I think moving it out of the deceptive trade practices is appropriate. Statutorily, we can create an obligation or that liability. And I don't think I have a problem with that, as long as we're saying, if you follow these best practices, and So now it still becomes a question of whether those were followed or not, but it does create a strong incentive for industry to actually implement and follow up and enforce those best practices. So I'm more than happy to explore that and look at that as a mechanism. And so my general thought is you can create a statutory cause of action. We just need to be careful about how we do that and very clear on what we mean.
And Mr. Chairman, a follow-up for our two attorneys on that. It seems like you certainly wouldn't, with that cause of action, want to ascribe all blame and all responsibility because of the password breach, but you would certainly want some sort of proportional or appropriate level. And I don't know if that then adds an additional layer of complexity, or how that would be phrased, or if the courts would just deal with that because they deal with those things.
Yeah, Mr. Chairman, I think it does need to be complex, because you can't have a strict liability standard because there's a breach, then you're automatically liable. What you have to say is there's a breach, and then what we have found, the breach was caused by the employee, okay? But is the employer then immune from it, or has no responsibility because the employer has put in place these procedures or protocols and training program XYZ? That is how you have to look at it, because if it comes back to a dishonest employee, you can't control a dishonest employee. All you can do is do your very best to train them and then have the proper practices in place. And that's what we're trying to encourage, is the employer to ensure that they have the proper practices in place. It's one approach to look at, one that I am willing to look at.
Mr. Chairman, one more point on following up on Representative Greer's thought there. I think the interesting upside to it that might make it even attractive is the idea that we're providing some clarity that if you use nationally recognized industry best practices, that it will help you to clarify that you're not going to have liability unless you've done something which is outside of those best practices, or there's some tangential liability or something along those lines. Whereas if you don't, then you are then going to have some liability associated with it. So honestly, if it's a fair standard, if we put together a fair standard that provides clarity, it's kind of a win-win at that point. So I think Representative Greer's points about that side of it, strengthens the idea of going about it this way. Thank you, Mr. Chairman. And good thoughts, Representative Greer.
Representative Lindholm.
Thank you, Mr. Chairman. And just for a thought, instead of, and I'm going through some of our old digital privacy task force bills, and there's a line that I think might be, this is when we were dealing with the university, essentially taking all writings. This had to do with them taking all of their emails back in the day. I'm sure the good chairman remembers those good times. But they said require the university to establish or prohibit the university from establishing standards on the retention and destruction of student writings and other communications, essentially putting the onus on the organization to establish those standards. And maybe something along those lines can be used instead of pointing at something that we don't know if it's out there or not, or what even best practices could be. We just put it out there that they got to establish standards to best protect consumers, something along those lines. That might be a route we could go.
Mr. Chairman. Well, I think all of the standards probably do exist with regard to data protection and integrity. If whether you're looking to NIST or ISO, I think you can find pretty much something for everything. And then if they developed, if we set it similar so that they developed their own policies or had policies in place that were consistent with nationally recognized best practices, that would allow them, in those cases where there were such standards available, then they would be adhering to those. And if there weren't, they would have policies in place. So I think it captures Representative Lindholm's concept, but also make sure that where those are readily available, you would utilize them and be able to point to them for protection. And again, we'll have time to work on this, so we don't probably have to finalize it now, but I think this approach is strong.
Okay, then I think what we're doing so that the committee is clear, we're going to go ahead and vote on moving this bill forward to our next meeting. We're going to create a working group to polish off the bill for us in December. As soon as we have the vote, I'll go ahead and assign some folks and anyone that's interested into that working group. And then all of this discussion that we're having right now, I'm tracking, at least with some of this, definitely on the unlawful practices portion. And, beyond that, I don't have a great opinion, but let's, we'll fold it into the bill, and then we can flesh it all out in that final meeting in terms of what we like and don't like. So if there's no other discussion, we'll go ahead and take the vote on just moving it forward. And I don't need a roll call vote for that. So I'll just, all those in favor with moving the legislation forward, put your hand in front of your face. Representative Yin followed the instructions precisely. Thank you. Those opposed? Okay, and that's unanimous. So we'll move the legislation forward. The working group, Senator Rothfuss, what are your thoughts? Anyone who's interested, obviously, but since this is Representative Lindholm's motion, I think he ought to spearhead that. Representative Lindholm.
Yeah, thank you, Mr. Chairman. I would request not to be the spear on this deal, just because I ain't gonna have the time to be able to put everybody together. I know everybody's strapped for time, but I just don't. I won't be able to do the job that you need done.
Okay. Do we have Senator Rothfuss? What are your thoughts?
Thank you, Mr. Chairman. Well, my original inclination was going to be Representative Lindholm, Representative Yen, and Ms. Long. And it sounds like Representative Lindholm can't be the spear, but maybe he can be the middle third of the spear or something along those lines. And we'll
you can choose the part of the spear you want to be. So
right.
So
However much of
it's
it
a great
interested.
Sorry.
And so, Mr. Chairman, perhaps Representative Yin could coordinate the logistics and be the head of the spear on this one and bring this group together.
Yeah, or depending on where the force of the spear truly derives from, it may be from the back end of the spear where it's held when it's tossed. That may be where you're at, Representative Yin. Representative Lindholm.
Thank you, Mr. Chairman. I would gladly give up my spot for an attorney to be on this, because I think there are some aspects that, because we are considering some pretty heavy-handed stuff that's most likely going to be turned over to the Judiciary Committee this next go around. It would make good sense to have an attorney on there if possible as a suggestion. I think there will be lots of big questions. Not that Ms. Long is technically, she does technically have her Juris Doctorates, but I think it's been a while since she practiced law.
She's a Juris Doctor from one of our highest legal institutions in the nation and oldest, and is a member of the bar.
Thank you, Mr. Chairman. Not a member of the Wyoming bar, though.
I didn't want to go as far to say which bar you're a member of. That's up to you to throw that one out there.
I wish I could wave in, but I can't. Thank you, Mr. Chairman.
Well, Mr. Chairman, let's just go with that group for now, and we'll see if we can draw in Senator Nethercott or find some time to get Mr. Kaufman involved. There's a lot of folks already weighed down. I know Mr. Kaufman. I want to make sure he has time to get the Dow legislation perfect, and didn't want to tap him additionally.
Okay. Well, I think we have a good direction going forward, though. Representative Yin, we're going to have you spearhead organizing that so we can get to work on it. We don't have a whole lot of time, but just if you would please, Representative Yin, copy myself and Rothfuss. And as a lawyer, I may decide to weigh in. We'll see.
Will do.
Okay. All right.
Are we to 11:30 yet?
It's 11:30. And we're going to move on to Chancery Courts, and Mr. Kaufman and Representative Greer are going to give us the most speedy update, but effective update, I'm sure. Representative Greer.
Mr. Chairman, I'll defer to Mr. Kaufman. Him and I have spoken, and he's got all the details, everything you need,
Okay.
except for maybe correction, but I'll bring it up later.
Okay, Mr. Kaufman and Representative Greer, bat and cleanup.
Thank you, Mr. Chairman. I will be very brief. So since our last committee hearing, just to remind you all where we're at in the process, the Supreme Court appointed committee that's working on standing up the Chancery Court has completed the rules. Those rules have been commented on by the bar and have been at least initially accepted by the Wyoming Supreme Court. There has been a couple of challenges with respect to figuring out the court location and the judges. And so what has happened recently is a suggestion by, my understanding is the district court judges themselves came forward and said, rather than holding this up with respect to appropriations and the process of finding new judges, why don't we sort of pivot a little bit towards a panel, an impaneled, I guess, group of sitting district court judges who would have to apply to the Wyoming Supreme Court. The Wyoming Supreme Court would set those qualification parameters and do the selection. And then those five judges would maintain their staff, maintain their chambers, everything. They would just be selected on a case-by-case basis to opt in on Chancery Court cases. And so I believe at this point in time that's kind of a favored path forward. The only issue was the legislation that had been previously passed set forth a relatively short time frame with which the Supreme Court had flexibility to appoint or impanel judges. And so right now, the thought is a very simple amendment to the existing bill to extend that deadline. And so, Mr. Chairman, do you want me to go ahead and discuss the draft bill?
Yeah, please go ahead. It's pretty straightforward.
Yeah, if you'll notice on the draft bill, the only change is essentially under 513-109, which this is the section that deals with temporary assignment or allows the Supreme Court to appoint a panel of judges. It extends the deadline or the date, I guess, by which the Supreme Court can do that from 2022 to 2024. And so this, I think, from the Supreme Court panel or the Supreme Court committee's viewpoint, would give a sufficient amount of time for that panel to be formed and to try it out. And obviously, during that period of time, they could be working towards permanent appointments, but this at least gives some sufficient runway. Mr. Chairman, that's pretty much the synopsis. I'll let Representative Greer weigh in if he's got anything to add.
So, Mr. Chairman, also, I think Mr. Kaufman is also retired district court judges who do on the bench from time to time, which could make a great panel. The one suggestion I'd have us consider on this is moving that out to my date's right, 2026. And the reason why I say that is, one is I think this is the right way to do it myself, is this panel, but get a good 5-year run to see if it works. It's not putting pressure on the budget for the judiciary. The reason why I say 2026 is give us 5 years to take a look, and then we would be coming around to that point with a full budget to see if it makes sense at that point in time to go to a constitutionally appointed judge, or maybe we make this process this way permanent. I think what is really critical from the folks I've spoken with is that let's get this damn thing set up and get it going. That's what I've heard.
Okay, I'm tracking with extending the date out. I think that's fine too. It probably invites that conversation that you just noted to Representative Greer, which is the comment that let's get this going. But I think if we just explain, it just gives them more time to work. It doesn't mean that we're not going to get it going. I can, just for the other members' edification, I've also spoken with the Supreme Court Justice Fox, and I now have the supplemental budget reduction kind of draft form from the Supreme Court, and a letter that they forwarded on to appropriations as well. And I think this is going to do a lot to help the Supreme Court make reductions to its budget that it wants to make in good faith effort along with the rest of the government, even though it's not subject to the executive branch's reductions. The branches of government is trying to make reductions in solidarity with the other branches, and quite frankly, this could have been on the chopping block, and nobody wants it to be, but since it's not off and running, it presents itself. And I think that this is a solution. We need to communicate to our fellow legislators that this is a solution to keep that from being a budget reduction in a very tight budget year. Mr. Reville.
Thank you, Mr. Chairman. A question for Representative Greer and Mr. Kaufman. If you're a practicing attorney advising a company on their selection of which state to incorporate, which state to form an LLC, or which state to have as your jurisdiction for legal purposes, is there any change in the attractiveness of selecting Wyoming because of the Chancery Court and the way that it's going to be set up now versus what was originally envisioned?
Representative Greer.
Yeah, Mr. Chairman, Joe, I don't think so. And the reason why I say this, and Mr. Kaufman and I were in the initial meeting when we were soothing egos to get this to come together, right? Is we heard from the district out of Tennessee, the district of Nashville, I think that's what it was, where they had 9 or 10 district court judges there, and they had beta tested this concept. And what they did is they shuffled work around and let one lucky judge get to do this kind of work versus all of the other types of work, and they found it to be wildly successful. What is most attractive about this is clearly the modified rules, which the Supreme Court and Wyoming Bar have already signed off on. That is what is attractive. Instead of spending hundreds of thousands of dollars in discovery, you can get right to the meat of the dispute and save hundreds of thousands, if not millions of dollars of business revenue. So I don't think it would change anything at all. I just don't.
Mr. Kaufman.
Yeah, thank you, Mr. Chairman. And I would just add to that no, from what was originally envisioned, again, this only, in my view, strengthens the structure of it, because now we can bring sitting experienced judges with their staff, with their law clerks, and so we're not really having to worry about the budget constraints that the state is under right now to build out that proper staff surrounding that judge. And so, if anything, I feel like it strengthens the argument that we can hit the ground running even sooner, as soon as this thing is formally launched.
Majority Floor Leader Dockstader.
Mr. Co-Chair, as a follow-up, then the Justice Fox in her letter acknowledges keeping some form or fashion of it moving forward then.
Yeah. Are you referring to the letter, her letter to what?
Mr. Co-Chair, you referenced a letter just a moment ago from her.
Oh, to appropriations? Yes, so the Majority Floor Leader, the chairs of appropriations simply indicates that the judicial branch is making reductions, that if it were to postpone the Chancery Court, it would be a savings of 1 million and almost 1.2 million dollars. That was an option that was presented. The alternative solution is exactly what Mr. Kaufman and Representative Greer presented, which is that if we use a panel of judges as opposed to setting this budget aside, which would have put in place a new judge and his or her staff, that we don't have to pause the project. They just need an extra set of time on their timetable in order to fill those vacancies, I suppose.
Thank you.
Mr. Kaufman? Correct.
Thank you, Mr. Chairman. I was just feeling badly after that question because maybe I did a poor job of explaining it. This in no way, shape, or form delays the standing up or the launch date of the Chancery Court. This just delays the deadline by which the Supreme Court has to make or formalize the process for brand new outside judges to be appointed. This just extends the timing with which the Supreme Court can use existing judges on a panel. So if anything, we view this as speeding the process up to get things launched.
Yeah, thanks, Mr. Kaufman. I think we're just gonna have to do a really good job of explaining this to our colleagues, because it's sometimes the simplest of bills and the shortest of bills will draw in and I when I look at it at first blush, I get the same. If I just looked at it and didn't understand the history, I would see that you're extending the deadline, and it feels to me like the project's not moving forward, but the reverse is very true here. So, okay, so with that, Representative Greer, is that your motion to extend it to 2025? Is that what you said?
So, Mr. Chairman, I'll move the bill, and then with a second, I'll have a quick amendment.
Sorry.
Second.
Yeah.
Okay, it's been moved and seconded. Go ahead.
Mr. Chairman, before we do that, though, I don't think we have any public comment, but we should take our public comment if we do before we actually take action on the bill.
Thank you. Mary Beth, do we
Mr.
have?
Chairman, I believe we do not have any public comment on this particular topic.
Okay.
Thank you, Mr.
Excellent.
Chairman.
All right, it's been moved and seconded. All those in, discussion, amendment, Representative Greer.
Yeah, so, Mr. Chairman, I would move to amend the deadline from 2024 out to 2026. And the reason 2026 to get 5 years and then to hit that regular budget cycle. Am I right on that even year? Yeah.
Yep. Second.
Seconded by Senator Rothfuss. Discussion on the amendment. Seeing none, all those in favor of the amendment signify by raising your hand. Opposed? Okay, that amendment is unanimously adopted. Back on the bill. Any further discussion on the bill? Other amendments? You want to go line by line through the bill? No? Okay.
Question.
All right. Question. This one we'll take a roll call vote on, Mary Beth, because we'll go ahead and make this a final vote.
Mr. Chairman, this is a roll call vote on 21 LSO 227 version 3 as amended. Senator Dockstader.
Aye.
Senator Driscoll.
Let's leave it excused for him, and maybe we can talk about leaving it open for him. He should be back, Mr. Chairman.
Senator Nethercott.
Excused.
Representative Greer.
Aye.
Representative Limholm.
Aye.
Representative Yin. I'm sorry, Representative Yin, I didn't catch your.
Aye.
Co-Chairman Rothfuss.
Aye.
Co-Chairman Olson.
Aye. All right. Very good, guys. We passed the bill out. In record time, too. Okay. Next up is out-of-state bank charter conversions. We need Division of Banking. I'm gonna go ahead and admit them in.
Mr. Chairman, I've just admitted them into the meeting.
Thanks, Mary Beth. All right. Chris, Albert, welcome.
Thank you, Mr. Chairman. Good afternoon.
You would just, you guys moved your room around.
We just changed the camera angle, actually. Yeah, we're ensuring we are properly socially distanced based on our expectations from the governor's office. So,
Excellent. If you would just introduce yourself and then take it from there.
okay. Mr. Chairman, Albert Faulkner, the commissioner here with the Division of Banking. Chris Land, General Counsel. Yeah, I think, Mr. Chairman, we're talking about the proposed legislation 21 LSO 189, understanding the dialogue here, and then see what actions the select committee does and how that interacts with Minerals Committee later this week. And I'll just give a quick overview of a reminder of what we discussed last time. And this idea for this legislation came about that from fairly recent conversations we've had from other organizations, state chartered banks that are located outside of Wyoming, and that they've been watching what Wyoming does in a number of fronts. The regulatory approach that we take out of this office, the legislative approach that the body takes, with just how they handle legislation and balancing kind of common sense legislation and yet making it clear as to what the intents of the legislature are. And then also what this committee and what our office has been doing over the last 2 years regarding fintech. Obviously, the SPDI charter itself is a big issue, but not necessarily directly tied to what they're looking at here. So we've had some of these organizations that feel that Wyoming might be a really good jurisdiction for them, and actually want to explore the idea of moving their operations to Wyoming. So when we looked at what the law did or didn't contemplate, we realized it really never considered the idea of an out-of-state, state-chartered bank moving to Wyoming, and not just having a branch location, but actually being chartered by the state of Wyoming and subject to Wyoming statutes and Wyoming supervision out of the Division of Banking. So that's what the idea spawned from, and what led to the bill that you have in front of you. Obviously, we had a couple initial drafts. LSO took that and kind of filled in the gaps and things of that nature. And so that's the bill before you, Mr. Chairman. And really, at this point, just stand for any questions that anyone has for us.
Okay.
Mr. Chairman?
Yeah, go ahead, Senator Rothfuss.
Thank you, Mr. Chairman. And Chris and Albert, thanks for your work on this. And there were a couple of changes and then a staff comment that I want to make sure that we get to, or a couple staff comments that I want to make sure we get to and have addressed before we work the bill. So do you have any concerns, first of all, about any of the language changes that occurred when this was going through the LSO review process? Were any of those tweaks of concern?
Chairman Rothfuss said, no, not really. Nothing that stood out of any concern. So I would, do you want to get through the staff comments? That's their direction, yeah. Oh, yeah.
Chairman?
Representative Greer.
Yeah, so I think Albert, or what I recall is we had that the nuance on the definitions of out-of-state bank and then out-of-state state bank, and this clearly applies to the out-of-state state banks, which is a out-of-state bank chartered in a state other than Wyoming, and I think that was the only cleanup, if I recall, from last time. Is that right?
Mr. Chairman, correct. Yeah, other than a little bit of what I would consider wordsmithing on LSO's part, but yeah, that was the just pointed to the different definition.
So then, Mr. Chairman, because we'll be seeing this here in about 5 days. I think we have you Friday afternoon. And it's, I'm just curious how this works if an out-of-state bank converts is chartered in Wyoming. Their operation is in another state. Does that bring that under? Do you audit or review, or what's your regulatory control over that particular bank? Is it with all their activities or just the activities in Wyoming? I meant to ask that last time. Sorry, I didn't.
Yeah, Mr. Chairman, Representative Greer. Yeah, so a couple parts to that question I'll respond to. Yeah, so they are subject to wherever they're chartering. The chartering authority is the primary supervisor. So what comptroller, now even at a national bank, they still have some state which are chartered, and so there might be certain state laws that apply. It's usually around consumer lending activities, typically. No different with the state charter bank. The other one is we also have, through the Conference of State Bank Supervisors, we have a nationwide cooperative agreement that also spells out the home state, host state responsibilities. Depending upon the size of the organization or things of that nature, we have the ability to, in essence, hire our colleagues from another state, things of that nature. So we have that with Montana, Nebraska, we work with them. And so it would be very similar here if we needed it, and if the host state wanted to be part of it. Well, obviously we have an entire agreement that's been around since 97, I believe, that kind of covers that and how that works. And it really, the idea is to keep the burden down on the institution, and so they don't have to deal with multiple states. They just interact with the home state for the most part.
Chairman Greer, also one part of your question is they would, to get a Wyoming charter, they have to move their headquarters and their primary place of business to Wyoming. Mm-hmm. So they would essentially move their headquarters from, Nevada, Idaho, or South Dakota to a city in Wyoming.
Mm-hmm. And then they can keep those other locations as branches if they want, or work with that which would become the host state, former home state. If there's closures or anything like that, that part is handled at the state that they came from. But my guess is, in reality, that those would be continued on as branches of the Wyoming institution.
Mr. Chairman, and Albert, I appreciate those comments. That's a huge selling point. We should lead with that one, okay?
Yep.
Go ahead, Senator Ruffus.
Thank you, Mr. Chairman. All right, Albert and Chris, now I want to go to the staff comments then and hear about each of them in turn. So page 4. Our first staff comment gets at some concepts about corporate action in the other state instead of corporate action within our state, and this kind of leads to an interesting discussion. I'm sure you've thought this through, but I don't know how much variance or variation there is with regard to corporate law interaction with state chartered banks in other states, and how that relationship of transfer would need to take place with regard to corporate statute. And the staff comment is specifically with regard to taking those actions using out-of-state statute instead of in-state statute. So how does this play out when you contemplate the interaction between a chartered bank in another state that is then also potentially domiciled, I think, and maybe I'm wrong on that, so please clarify if that wouldn't be a concern, but if its corporation is domiciled elsewhere, and then which state will the actions be governed by as you're doing the transfer? How is that working through?
Thank you, Mr. Chairman. It's Chris. It's not really a concern because to convert to a Wyoming charter, we would likely require them to form a Wyoming corporation here, and the actions would be governed by Wyoming law. They can keep their holding company if they have one in whatever state they want, but they would likely have to abandon whatever corporation they have in their home state currently.
Okay, so Mr. Chairman, then as I understand that, we probably don't need anything pursuant to the staff comment because your expectation would be create a Wyoming company.
Yeah.
And then that Wyoming corporation would be the entity that would be governed pursuant to the statutory change, and that's what would receive the charter. So you would be operating entirely under Wyoming statute, as I understand it. Is that right?
That's correct, Mr. Chairman.
Okay. Anything else on that point that we need to consider? It sounds to me like we're fine on that staff comment.
Yeah.
I do have one more question, Mr. Chairman. Whoever he is on my screen.
Yeah, go ahead, Representative Greer.
Just curious, why have this be effective immediately, other than that seems to be the modus operandi of this committee?
Mr. Chairman and Representative Greer, so the two institutions we're talking to, they're already starting theirs due diligence, and the idea would be that by the time that this went through the legislative process, there from when they first started would be, we're talking about 8 months or so, and I think they would be ready now. Can they wait 3 more months? Probably, yeah. But that was the only reason is like we knew we had something there. But there's also other opportunities that institutions can, or other things that they would need to do anyway. So that one's I don't really have a preference one way or the other.
The federal regulators have to approve this. Like even if we approve it, we would hand it off to them for approval, or they would do it concurrently. So yeah, it's going to take time anyway.
Okay.
Senator Office.
Thank you, Mr. Chairman. On to the second staff comment, page 5 at the bottom, is just including some language somewhere that provides for rulemaking authority specific to these requirements. It's my assumption that the paragraphs that we're amending already have appropriate rulemaking authority directed at them, so to speak. And so my assumption is that we probably don't need it, but I do want to check in and see if it would be beneficial or necessary to have explicit rulemaking authority with regard to these out-of-state bank rechartering provisions.
Mr. Chairman, Chairman Rothfuss, I think we're more than covered. It's either chapter 1 or chapter 2 that talks about rulemaking authority in order to, in essence, administer Title 13. So in my mind, that would be covered. I don't think there's a need to have anything specific here.
Okay, thank you, Mr. Chairman.
Okay. Any other discussion on with the banking division on the bill? Seeing none, Mr. Land, Commissioner Faulkner, do you have any closing thoughts or remarks?
No, Mr. Chairman, other than, we've had a busy week. Just by way of update, you may have seen the Two Ocean no action letter come out last week, and then Avanti received their banking charter on Wednesday. So also keep an eye out for the release of our supervisory manual for SPDIs in the coming weeks. But other than that, I'll leave it to you guys.
It's a great point. We should consider renaming the Wyoming Division of Banking to the Wyoming Division of Firsts, because we've given you guys a lot of firsts. You're welcome.
Yep. Thanks.
Mr. Chairman?
Yeah, Senator Rothfuss.
Thanks, Mr. Chairman. I think most of the viewers at home, so to speak, are familiar with Speedy Bank and the Avanti application approval. I don't know that everyone is as familiar with what's contemplated by the no action letter. It sounds trivial since it actually has no action in the title. If Mr. Land or the commissioner would provide just a little bit more detail about the implications of that, what the no action letter means, I think that would be useful.
Or possibly Mr.
Yeah,
Mr.
or
Ravel.
and Joel can certainly weigh in as well. But since Mr. Land was bringing up the big week, I thought that one deserves a little bit more detail, perhaps.
Okay, Mr. Land, give us the news so that everyone at home can understand why this is a big Wyoming first.
Thank you, Mr. Chairman. So under the Investment Advisors Act, investment advisors are required to use a qualified custodian to hold their customer securities. And there's been a bit of controversy in the digital asset space over the last couple of years about whether a trust company qualifies as a qualified custodian. And the SEC hasn't been ready to issue an interpretive letter on this issue, citing that it's a state law matter generally, or for state banking regulators. So we put together a thoughtful legal analysis on why certain trust companies, such as Two Ocean, that are engaged in fiduciary activities likely qualify as a qualified custodian, and in the same way as an SPDI or another state charter bank. But I'll stop there and let Mr. Revel opine on whether he thinks we did a good job or not. So
Let's do that.
yeah, no pressure. Yeah.
Mr. Chairman, Mr. Land did a great job of explaining it. I have nothing to add there other than thanks to the good work of you all as legislators and to the Division of Banking. Wyoming is really breaking ground here in this exciting new asset class. So very grateful to be here.
Great. Thank you, Joel. Thank you, Mr. Chairman.
Representative Lindholm.
Thank you, Mr. Chairman. Mr. Land and the Division of Banking had mentioned how there was quite a bit of controversy around whether or not trusts could be qualified custodians, and that's been the big debate all along. And I would like to note how hard Joel dunked on me, because when Joel first joined the select committee, me and him had a hell of a debate on me saying that trust companies are not qualified custodians up and down the line. And so he just quietly just bid his time, did his work, and boom, he's the only one that is a qualified custodian now. So that's good. Good job, man.
Joel, further comments on how you schooled Representative Lindholm?
I just wanted to say thank you to Representative Lindholm. I haven't been able to dunk for years, so it's great to have that back. No, thank you. Appreciate it.
Awesome. Chris, Albert, anything else?
Nope.
All right, guys.
Thank you.
Senator Rothfuss.
Thanks, Mr. Chairman. And so for this legislation, our task really was to work it through, make sure it was in good shape to hand it over to Chairman Greer and the Minerals Committee later this week. I don't know if there's anything else Chairman Greer wants from us before then, but I think we're in pretty good shape here.
Well, we do have one more. We do want to hear from the bankers.
Oh, absolutely. Yeah, we'll get our public comment. Thank you, Mr. Chairman.
Mr. Meyer. Scott. You can come on in now. You're in. You're just muted.
It's clear he's watching the YouTube, so let's warn him beforehand. Scott, when you can hear us, turn your YouTube off and only come to the meeting. Thanks.
Somebody write on a piece of paper, Scott, and hold it up. Oh, okay, we got you. Scott, go ahead and introduce yourself. And please, if you have any comments, we'd love to hear them.
Hello, could anybody hear me?
We can hear you now.
Good, because I can't hear anybody there. I don't know where the sound went off, but I do want to just make a comment that I've had the same concerns. I guess my members had the same concerns that were brought up by Representative Greer. Of course, the last thing that we probably wanted was to have an out-of-state bank to get a charter here and never be here. But in our conversations with Commissioner Fortner and everybody in his office, that I think that this is a very good bill, and we stand in support of that bill.
Thank you, Mr. Meyer, for your comments on behalf of the bankers. It's always a wonderful kumbaya moment
But in our conversations,
when we can have the bankers, and Representative Lindholm in a kumbaya. So that's awesome. All right. Public comment. Mary Beth, do we have others who would like to comment?
Mr. Chairman, I do not believe so.
Okay, that being said, do we have a motion on the bill?
Mr. Chairman, we're not taking a motion. We're going
Oh.
to vote on the bill. We're going to just hand it over as long as everyone's okay with it. We could do an informal motion if we wanted to support it and forward it to the Minerals Committee. I think that's in order. So I will make that motion that we support Minerals Committee's favorable consideration of the draft legislation on behalf of the Select Committee.
Okay, so it's moved and seconded to send this bill over to Minerals Committee with our do pass recommendation. All those in favor, or any comments? Hold on, no comments. Okay, all those in favor, go ahead and raise your hand. Those opposed? Okay, so unanimously, we are sending this to you, Representative Greer. Thank you. Let us know if you need anything else on it.
And Mr. Chairman?
Go ahead.
Thank you, Mr. Chairman. We've got Senator Driscoll here now. He was unable to be here for the vote we had earlier. That should be held open for him since he was coming back. And I don't want to put him on the hot spot, but we left the vote open, Senator Driscoll, on the legislation for, it was the SIM card. No, that wasn't the SIM
No,
card.
it was Chancery. It
That
was
was the
Chancery
Chancery
Court, Chancery Courts, Senator Driscoll.
I vote aye.
Great. Thank you, Mr. Chairman. Thank you, Senator.
Mary Beth, I'm assuming you got that?
I did, Mr. Chairman.
Awesome. Okay. Let's go ahead and move into public benefit corporations. And I think we're just going to start, actually, we're going to start with Mr. Kaufman. Is that right, Mr. Kaufman?
Oh, we certainly can, Mr. Chairman. And I'm happy to take direction from you on what you want me to first discuss. If you want me to give kind of a background of the bill again and a general overview, or if you'd like me to discuss the current bill draft, just let me know what you prefer.
Well, let's just do a little bit of both to kind of accelerate this. Why don't you give us some background on what brought us to here, and then the bill draft that we have in front of us, and what is different, if anything, from the last meeting where we saw this bill.
Absolutely. Well, Mr. Chairman, just to start with, if you'll all recall, there was a discussion a few meetings back about this idea of a public benefit corporation. This idea generated, well, from a couple of folks who were taking a look at some alternative entity forms and how they do business in other states. By way of background, 30-some, I think 34, 35 different states have adopted some form of a benefit or public benefit corporation. The draft bill that we have before us is based generally on the Delaware Act. The idea behind a public benefit corporation is pretty straightforward. In a traditional corporation, the law is pretty clear that the directors of that corporation, their primary duty is to maximize shareholder profit. And so when directors take action or do something that in some way, shape, or form reduces that profit, they can, not always, but they can subject themselves to liability in certain contexts. So this is often referred to as the business judgment rule, sort of broadly in its broad application. There's a number of lines of federal litigation and cases that support this proposition. And it's very, very commonly litigated in the publicly traded company realm, where, again, directors first and foremost obligation to their shareholders to maximize profit is often tested. But nonetheless, this use case has grown over the years, and the idea is simply that entities who would like to have a for-profit structure, in other words, a nonprofit structure for their entity doesn't work for whatever reason, but they would still like to be able, that entity would still like to be able to take into account other non-shareholder interests. So the statute refers to that as stakeholders, outside stakeholder interests. They can do so without necessarily violating that statutory or common law duty to their shareholders. An example that I've given many of you before, but there's a well-known bread and baking goods company based out of Massachusetts. And years ago, they as a company sort of made the prognostication, we're going to become a public benefit corporation because we want to buy American wheat and we want to support the American ag market. We don't care necessarily if that, maybe affects our profit margin a little bit. Obviously, they're still aiming to be a profitable company, but their mission is that they want to support American wheat farmers. And so that's just an example. There's many applications, obviously, for this type of entity, but that's the general gist of it. I think it's important for the committee to understand that this bill was drafted in such a way as to frame it as a supplement to the Business Corporation Act. So this does not change or fundamentally affect the underlying Business Corporation Act in Wyoming, which we've all become so familiar with and supportive of. This is akin to a supplement. So much like a corporation could elect to be a closed corporation, and thereby, in addition to the underlying base Model Business Corporation Act rules, they're now also electing to follow a supplemental set of rules, which in the statutes are called the closed corporation supplements. This would be just like that. So fundamentally, you're still a corporation. You're otherwise, unless the supplement modifies those duties in any way, shape, or form, the entity would then still be a corporation, but just electing to follow this new set of supplement rules. So that's kind of the structure. Mr. Chairman, do you want me to stop there for questions, and I can go into the bill specifically if you'd like and cover a little bit of what it does?
Sure. Do we have any questions at this point, committee? No? Okay. Just keep on keeping on, Mr. Kaufman.
Excellent.
Oh, wait, sorry. Representative Lindholm, just go ahead.
Yeah, thanks, Mr. Chairman. I did, and not a question for Mr. Kaufman, but I do want to note during the last committee meeting, I had declared a conflict because an entity I was working with was looking at utilizing a public benefit corporation. That is, they are no longer pursuing that at this time. So my obligation to note that is gone because they are no longer pursuing this. Thank you. In Wyoming, I should say.
Representative Greer.
Yeah, thank you, Mr. Chairman. Mr. Kaufman, just aside from the logistics, this might be more with question for LSO, but like the closed corporation supplement is a different chapter versus an article. And I have to be honest with you, I don't know the nuances of that. So I know with a closed corporation supplement says these are, so you're doing the same thing here, which I think is fine. Finally get my head around the fact, I think it's okay. All right. But with that is, what is the nuance between an article, which we've got articles broken out for foreign corporations, dissolution, all the way through the corporations, versus having another chapter, which is another sort of add-on to the corporations, the Model Corporations Act. If you know the answer to that.
So I'm sorry, Mr. Chairman, was that question for me or was that for LSO?
Well, Mr. Chairman, I asked Mr. Kaufman. He's got the nice haircut and the good look. I thought that'd be the answer.
Mr. Kaufman, if you have the answer, we would love to have it. If you don't, that's okay.
Yeah.
We can ask LSO what their thoughts are too.
Yeah, Mr. Chairman, and I'll defer to LSO on structurally where the best place for this to be in the statute is. But again, as I was explaining, it is intended to be a supplemental application and a supplemental concept. Representative Greer is absolutely right. As it's drafted, it appears in the body of the act. So in application, Representative Greer, I mean, I as someone who deals with these statutes a lot, I would argue that they have essentially the same impact and same effect. I think it's just a matter of preference with respect to how the statute appears, quite frankly.
Mr. Hopkinson.
Thank you, Mr. Chairman. Representative Greer, in response to that question, I'll do a little bit of digging just to make sure the information I'm going to give you is not in error. But I think to a certain extent, it's really more about making sure that everything that's in there conforms with everything else. So we're talking about the minor language, such as using the term chapter versus article, etc. I don't think that matters, or that's what matters more so than whether or not it's in a separate chapter versus a separate article, as long as everything is consistent across the board. So the ultimate effect is the same, whether we put it as a new article versus a chapter. But that, where it's at now, I think works fine. If there's a specific reason or preference to move it into a separate chapter, I don't think there'd be any issue with that either, as long as all of the language is consistent.
Yeah, Mr. Chairman, I'm not recalling ever reading any case law with a distinction on that. That's just why I was asking. I think I expressed this to the co-chair. I just want to make sure we don't do any harm to our existing structure is all that. If we're doing this as a true supplement or add-on, that we're doing it correctly. That's all.
Mr. Chairman.
Senator Rothfuss.
Thank you, Mr. Chairman. And after talking to Representative Greer about this, so, I kind of share the thought that, and I had asked, do we have other circumstances where we have this embedded, or we have a supplement embedded as an article instead of a new chapter? Because, upon reflection, after talking with Representative Greer, you can see that the parallel drafting would suggest that it be a new chapter entitled For-Profit Public Benefit Corporation, and perhaps supplements, although we didn't do that, I think, with the where is the close corporation is called a supplement. Okay, so you could potentially call it a supplement at that point as a chapter 31 for-profit benefit, public benefit corporation supplement, or something along those lines, just so that it's clear that the intent is similar to that. So, Mr. Hopkinson, what are your thoughts on that? It sounds like it's not that big of a problem if we wanted to redraft it in that way. And I guess I'd ask for your thoughts on calling it potentially a supplement, although this is standalone. No, it's referring back. So what are your thoughts on that?
Mr. Chairman, I will do some more digging on that just to make sure we do have the correct methodology there. I think if it was going to be an issue, it would have been caught during our internal review. So I don't think that there's an issue. Now, stylistically, I think it would be perfectly fine creating a separate chapter for it, similar to the closed corporation supplement. I don't think there's necessarily an issue there. I guess what I'd ask for just a little bit of time to dig into that and provide a clear answer to the committee as far as which is preferable, make sure we've got it right.
Yeah.
So Mr. Chairman, we did the same things, a separate chapter for the closed limited liability act, and I don't think does anything for our discussion today. I think we can move it forward. I guess the question is do we want to be consistent in how our law looks when we're going there? And I just want to make sure we do it right. That's all. I don't think it should prohibit moving forward and discussing this because we're really talking about form in a lot of respects, form over substance here.
Mr. Chairman, one other thought on that form. I imagine somebody who's not sitting there with LexisNexis or something in front of them that's trying to ascertain whether Wyoming, what types of corporations we have, and contemplating forming a corporation. And it does seem to me that if we had it placed within Chapter 17, it would be more challenging for them to identify that that's a thing. And that if we had it as a new chapter of its own entitled for Private Public Benefit Corporation Supplement, that anyone who's searching for it that isn't deeply versed in Wyoming statute would readily find it. So I do kind of think that's a superior form just as a first inclination. Thank you, Mr. Chairman.
Mr. Kaufman?
Thank you, Mr. Chairman. Would you like me to go ahead and summarize the bill real quickly for everyone?
Yeah, you can. And I mean, without polling the committee on that, I think there's a general consensus of the structure makes a lot more sense. I mean, I'm a lawyer. I pick up the statute book. Even as a lawyer, I'm going to look, as I pick it up, it would be a lot easier, like you said, Senator Rothfuss, just to scroll down and see that versus comb through and, okay, find as I'm reading through, okay, actually here it is, versus being set out. I think being set out entirely separate makes a lot more sense than me too. And I think we can fix that pretty simplistically. So yeah, Mr. Kaufman, let's just proceed with the bill.
Thank you, Mr. Chairman. I know we're trying to make up time, so I'll do this very, very quickly. Referring to, obviously, first page of the bill, just gives an overview and introduction to the idea of a public benefit corporation. The second page of the bill defines what a for-profit public benefit corporation is. This would be a new concept within Wyoming statutes, and that's a for-profit corporation that's intended to produce a public benefit and operate in a responsible and sustainable manner. That can mean a lot of different things. The statute goes on down below to describe what possible public benefits might mean. Right now, that's defined as a positive effect or reduction of negative effects on one or more categories of people, entities, communities, interests. And then it lists a whole range of things such as artistic, charitable, cultural, economic, educational, environmental, literary. And so in other words, the attempt here is to cast the net wide with the list of possible things that a public benefit corporation could use as a basis for consideration. And then public benefit provisions is discussing the articles. 1716, 1902 just generally discusses the applicability and the formation. Obviously, is the same as with 1903. There does have to be some threshold requirements met for these entities with respect to their articles of incorporation to set forth clearly, the public benefits. There are some requirements placed on these entities that when they deal with their shareholders and when they're holding themselves out to the public, they do have to make it known essentially that they're a public benefit corporation. There's clarification in 1904 that nonprofit corporations cannot be constituent corporations through any merger or consolidation with a public benefit. That's, I think, just a good policy decision. We're making a determination here that you can't gamesmanship essentially the nonprofit and the public benefit corporation. You've got to be one or the other. Stock certificates and notices, again, in sort of concert with the idea that these entities have to give notice to their shareholders, have to give notice to individuals that are dealing with the entity that they are a public benefit corporation that's included in here. 1719, 1906, this, again, it's sort of my estimation is kind of the meat of the act here. And this deals with the duty of directors. And this gets at what I was explaining to the committee a few moments ago. And that is, again, that general rule with respect to for-profit entities is that directors have a first and foremost obligation to consider the maximization of profits for their shareholders. And so this statutory section just sets forth that directors may now undergo a balancing test of balancing not only the interests of the stockholders, but the best interest of others who they deem to be stakeholders. And so, and in doing that or conducting that sort of balancing test, they're not necessarily, violating any fiduciary obligation that they have to the corporation. 1716, 1907 sets forth some periodic statements that are required for public benefit corporations. Again, information that they have to provide for transparency purposes. And then I guess moving down to page 10, sorry, Mr. Chairman, I'm trying to do this very quickly. 1716, 1908, this talks about the enforcement of that balancing requirement. And this again, I'm going to read this first portion because I do think this is important to understand. It says, unless otherwise agreed to by the shareholders, so this can be modified by bylaw or governing document, any action to enforce the balancing requirement, including any individual, derivative, or other types of proceedings, shall not be brought unless the plaintiffs in the proceeding own individually, collectively, as of the date of the proceeding, at least 2% of the corporation's outstanding shares. So this is an important concept. So just real quickly, the statute makes note of a derivative action. A derivative action is very simply when a shareholder of a corporation has an action against the corporation because someone in the corporation is not acting in the best interest of that shareholder. And so those actions are brought all the time against directors or against officers. And so what this statutory section is essentially setting forth is that if you are a stakeholder, you don't necessarily have standing to bring a derivative suit. If you're a shareholder, you don't necessarily have standing to bring a derivative suit or something like that, only with respect to this idea of whether or not the director has balanced those interests that they're considering, unless you have more than 2% of the corporation's outstanding shares. Again, this is modeled off of what Delaware and many other states have done. I personally have done some extensive research on this, and it seems in policy to be a very good threshold. 1716, 1909 just indicates that this is not in any way, shape, or form anything in this section applicable to for-profit. I'm sorry, is applicable to a corporation that is a not-for-profit public benefit corporation. See, Mr. Chairman, I think the rest is just some cleanup language regarding the sandbox and some definitional sections. So with that, I'll stop. I will make note, Mr. Chairman, that at the last legislative hearing, I and some others made suggestions of a few cleanup amendments. I think all those amendments have been made. So this draft, as far as I'm concerned, is in good shape.
Thank you, Mr. Kaufman. Any other questions for Mr. Kaufman, Senator Office?
Mr. Chairman, I was just going to note that is the difference between this draft and the previous draft is there were an assortment of changes that were suggested and brought by Mr. Kaufman, and all of those have been incorporated into this draft.
Great. Okay, next we have Professor George. I'm going to butcher it. But I want the C and the S combined together are throwing me off.
Pretend X, Mr. Chairman.
What's that? You cut out. Say it again.
Pretend that the C and the S are an X, Mr. Chairman. Oh. I think that should make it perfect.
All right. Thank you, Professor. Go ahead and introduce yourself, and then please feel free to provide us your comments.
Thanks very much, Mr. Chairman. I'm a professor of law here at the University of Wyoming College of Law. My primary areas of teaching and research include business law. I've been teaching on the topic for, goodness, about 8 years, I think. No, 9 years. You'd think I know that by heart, but it turns out that I don't. I'm just realizing. And I've researched and written on this topic as well. So I'd like to speak today in support of the proposed proposed legislation, excuse me, on public benefit corporations, or PBCs, if the chairman will allow me. As the PBC is a hybrid entity that allows its owners directly to address social needs, but commercial activity is the driver of its revenue. And the legislation would require the directors of public benefit corporations or PBCs to serve 3 interests. 1, the pecuniary interests of stockholders. 2, the interests of those materially affected by the corporation's conduct. And 3, public benefits specifically enumerated in the Articles of Incorporation of the PBC. And although we might discuss whether this is the optimal set of interests, a few points are clear. 1, the common good is a PBC's primary purpose, and the common good includes a number of things. It's not just sort of what we think of as charity nowadays. The first are the purposes specified in the Articles of Incorporation. Whatever the specific public benefits are that the shareholders or the stockholders would like the corporation to favor or pursue or fund or help. But other benefits include enabling all of the benefits that the corporate form allows, like limited liability, very easy scalability, expert management, the separation of ownership and control, and so on, things like that. It also, another benefit is the generation of tax revenue, as contrasted in this case with just a nonprofit corporation. Nonprofits don't pay taxes, whereas a public benefit corporation does pay taxes on the revenue it makes. It just then has the flexibility to use that revenue for multiple ends, other than just maximizing shareholder wealth. And just more generally, the generation of value, right? That includes creating jobs, products and services which are good for consumers, and general economic growth all around. And it does that, second, it does that without relying on private or public charity. It does all of that by engaging in a sustainable, profitable business that doesn't rely on anything but its customers to exist. And importantly, importantly for our discussion today, it's remarkably unclear actually whether any other off-the-rack entity, any other off-the-rack solution like the nonprofit corporation or the general business corporation, the limited liability company, what have you, whether any of these other off-the-rack solutions can do all of the things I just mentioned as efficiently and as effectively as a PBC could. So the shareholders of a general business corporation can object and in fact bring a derivative suit if their firm engages in too much charity. And these entities, the general business corporations, cannot exist to serve ends other than shareholder wealth. Nonprofit corporations, as I mentioned, don't pay taxes, and they face quite a few restrictions on their sources of revenue and their operations. And the other entity types that probably, and I say probably because it's actually not certain, that probably can serve non-wealth ends don't carry the same benefits that the corporate form enables. So the result is that the investor who wants his or her business to serve, or its business, because one of these can be a subsidiary, to serve non-wealth ends faces a great deal of uncertainty in whether it's even legally possible. And that's not even to speak about whether it's practical under the current off-the-rack legal solutions. The public benefit corporation's an entity designed to enable, while minimizing uncertainty, of which there's quite a bit, and which is quite anathema to business people, enable the public benefits while preserving the benefits that come with wealth generation. And thank you very much.
Thank you, Professor. Very helpful. Senator Rothfuss.
Thank you, Mr. Chairman. Professor Moxery, do you have any thoughts or any concerns with the way this is drafted, with the way it's laid out? We had a little bit of discussion even about form. I don't know if you wanted to comment on that, but anything that you see that we could improve upon?
So I do. On the form point, which I confess I hadn't thought of, I tend to agree with the committee that making it more easily identifiable in the statute would be a good idea. There is one bit of language about the purposes to be served that I think that I would remove. There's the phrase that reads, quote, the interests of those materially affected by the corporation's conduct. I would remove that. The reason is that it could lead to absurd results, like one of these public benefit corporations having to serve interests directly adverse to those of the firm. So like contractual parties in other states, for example, with no connection to Wyoming. I think that writing Wyoming's PBC law without that requirement would make it decidedly better than Delaware's, because it would allow the shareholders to identify the interests they do want to serve and not be tied to serving interests they don't want to serve. And I think, in my humble opinion, and truly humble, because there may be others who disagree with me on this, I think it would make it the best in the nation, because interests contrary to Wyoming's or other shareholders wouldn't have an opening to hijack a public benefit corporation. And I think that in turn has the potential to attract these entity types to the state. So in my opinion, removing that provision, thus allowing shareholders to specify and cabin the public benefits served by their investments, would make the bill pretty much perfect, actually.
And Professor Moxery, just to be clear, you're talking about on the bill, I don't know if you have it in front of you.
I do.
Page 2, lines 12 through 13 in the definition of a public benefit corp.
So I have working draft 0.4. Is that what I should be looking at?
Okay, we're on 0.6.
0.6. I'm behind the times. I apologize.
But at any rate, you're talking about the definition of for-profit public benefit corporation.
Correct. The part that reads, so it actually appears in two sections. One is there, a for-profit public benefit corporation shall be managed in a manner that balances one, pecuniary interests of the stockholders. That's good. And then the next phrase is the one that I would remove, the best interests of those materially affected by the corporation's conduct. And similar language appears in section, or I guess subsection 1906A, when it talks about the duties of directors.
Okay, gotcha. Thank you. Senator Rothfuss, you had a follow-up?
Mr. Chairman, that was literally what the exact question I was going to ask. So I see Representative Greer's hands up.
Representative Greer.
Okay, Mr. Chairman, Professor, I like the idea of removing that. The question is, and that leaves us with a statute that says a for-profit, for doing this right, shall be managed in a manner that balances the pecuniary interests of the stockholders. And is that fine? Or is there a more general term? What are we balancing by having that language sentence is all?
Yeah, so Mr. Chairman, it would be the pecuniary interests of the stockholders, and then a little stricken out section, and the public benefits identified in its articles of incorporation. Okay. I apologize, I was unclear.
Yes, I was one didn't go all the way. Thanks.
Okay. Yep, that's why I was trying to make sure I got when you read it back to me, Professor, you're stopping right before that and in the cut, and I think we're tracking you now.
Great. I apologize for that, Mr. Chairman.
No, that's all right. If we didn't have so many different versions of a bill, it would mean we didn't work hard enough on the bill.
Right.
Mr. Kaufman?
Mr. Chairman, I just want to say for the benefit of the committee that Professor Moxery and I have had a chance previously to discuss this, and I'm in complete agreement with striking that language anywhere it appears in the bill. And quite frankly, after Professor Moxery informed me about this, it re-prompted me to go back and do a little bit of research. And I do agree with him that that removing that simple phrase from this bill, I think it not only puts a distinct advantage on Wyoming's version of this bill, but recalling to last committee hearing, there was some discussion about conceivably could one of these entities be used, for an environmental purpose or something like that. And while of course any entity could be used for any purpose, we can't stop that. I do agree that with Professor Moxery that by striking this, I think we protect ourselves a little bit differently than any other state has thought to ensure that these entities are being used in the way they're intended. So I fully support that.
Representative Greer is good. Other questions or other questions for the professor? I'm sorry. Professor Moxery, do you have any other remarks or closing comments?
No, Mr. Chairman, other than that, I'm at the committee service. If there are any follow-up questions, later on, I'm always here and available. I love my new home of Wyoming, and so I stand ready to help it however I can.
Well, good, and thank you, and welcome to Wyoming. And you've just been enlisted by the Select Committee.
Okay.
We'll put you to work, Professor. We appreciate that. Appreciate all your insight as well.
Thank you very much.
All right. Do we have Mary Beth? Do we have other public comment?
Mr. Chairman, we do not.
Okay. Well, I know it sounds like we have at least 2 potential amendments. I think this bill's completely workable at this stage. So if we have a motion on the bill, I'll take it. Representative Lindholm?
Yeah, I saw move.
Moved and seconded for the bill amendments. Mr. Kaufman.
Mr. Chairman, forgive me if this is not procedurally correct, but I would just suggest a simple motion that strikes that phrase anywhere it appears in the bill that Professor Moxery just mentioned. The best interest of those materially affected by the corporation's conduct. I think that appears, if I'm not mistaken, I think it appears 3 different times in the statute, but I would make a motion that language just be stricken throughout.
Okay, it's moved and seconded to strike said language. Discussion on the motion. All those in favor, please raise your hand. Those opposed? That's unanimous. And Mr. Hopkinson, you'll find you'll strike that on page 2, lines 12 through 13, and then find the conforming throughout the bill.
Mr. Chairman, it does. It appears 4 times throughout the bill, but it looks on my initial review to be pretty consistently just a striking through of that portion, and I don't think it'll change otherwise the meaning of those paragraphs. So.
Okay, if we have one more lawyer count, we'll have maybe 5 times. Representative Greer?
Yeah, Mr. Chairman, if I get the committee to look, it's on page 8, line 7. So it's 1716, 1907B. Just want to make sure that that's where that line. So it's the information you provide to stockholders. Statement to the promotion of public benefit. And then this is identified in the articles. And sorry, just wanted to make sure that we were uniform.
So you're saying this amendment would strike line 11.
Yes, okay. It is consistent. Sorry.
Okay.
Yeah, thanks.
Okay. Now we'll
Mr. Chairman, I agree with Representative Greer. I think that's consistent and works as a deletion.
Yeah, I agree as well. We'll just, Mr. Hopkinson, just triple check when we're removing this, that it all makes sense with the paragraph in the section that we're playing with, but it looks like it's all going to line up. But let's just make sure we get it right. Okay, further amendments, Senator Rothfuss.
Thanks, Mr. Chairman. I would prefer it as a chapter, and I think everybody else is probably in the same boat. So I will move to amend to basically just redraft from a form standpoint to put it as a chapter instead of an article, and provide all of the necessary conforming amendments to do so.
Representative Greer.
Yeah, I'll second and then ask Senator Rothfuss as well. We would have a short title component added to that basic form. Again, that gets to, I think, the point that was discussed of how is this easily or more easily found? So right?
Yeah, Mr. Chairman, that's correct.
Yeah. So what are you gonna call it, Senator Rothfuss? Are you gonna call it do you mean the For-Profit Public Benefit Corporations Act? Supplement?
Mr. Chairman, I believe supplement is how we did it before. As long as we're comfortable calling this a supplement, I think it qualifies as a supplement. I'd ask Mr. Kaufman or Representative Greer if supplement language is appropriate, and then provide flexibility maybe to Mr. Hopkinson in case that he deems us wrong. But I think that's accurate.
So it'll look like the closed corporation supplement.
That's what I would think. Yeah, modeled after that.
Mr. Kaufman, is that legally make sense?
Mr. Chairman, I'm in agreement with that. I think that makes perfect sense.
Representative Greer, you're
Yes.
in agreement with that too? Okay, so everyone understand the motion is to remove the language that we set this out inside of an article, and we actually break it out into a chapter by itself, and we're gonna label it as such so that it is the supplement, the For-Profit Public Benefit Corporation supplement. Representative Greer.
Yeah, sorry, Mr. Chairman. I think we should, I guess my suggestion is, yes, let's vote on this, but give the chairman the discretion to look at the final form. And if there's a question, come back to the committee with it. And the reason is I'm looking at the closed corporation supplement. We have a short title, then we have an application of the Wyoming Business Corporations Act. And so I think it's important that we have those two tie-ins, two sections to tie this in, and then we can drop to definitions. But I think it'd be good to vote on this, but to give the chairman a chance to take one more look at it to make sure we've got that conformity.
I see what you're saying. So there is a short title followed by 17-17102 application of the Wyoming Business Corporation Act to the following sections. You're suggesting that this format may be a little more than just moving out of Article 16 and into chapters, but more specifically, or I'm sorry, moving out of Chapter 16 into its own chapter, we may have to add a new section for application.
And Mr. Chairman, I think that's it. I think it's just those two.
Okay.
Just to conform and tie it together. That's all.
Got you. Mr. Hopkinson, does that make sense?
Mr. Chairman, it does, and I was just looking at the bill draft. Currently, Section 1902, I think maybe the preference of the committee then would be to kind of take the language that we see in 102, 1717-102 in place of the language that's currently in 1902. There would be some consistency there across those applications, and I think they accomplish the same purpose, if that makes sense for anybody that's looking at that statute.
Yeah. No, you're talking about instead of 1716-1902, you're going to have this, you're going to scrap that, mirror 1717-102 and set the full thing out. That'll be set up front instead of after definitions, but before definitions?
Correct. It would be before definitions. It would be, I would just kind of mirror the short title application and then the definition section.
Representative Greer.
Yeah, and so Mr. Chairman, But I don't think we have to worry about the professional corporations, which is 1717 to be a reference to it. If you look like you had it on your screen there, 177102C, I think that's good saving language regarding that it does not repeal or modify any statute or rule that would apply to a corporation that's organized. Again, I'm looking at that stability in our law. So I just want to make sure we get those things. They're simple. They're the first two items out of the box. Just get them locked down, and then the rest of this is great.
Yeah, Mr. Chairman, I think Representative Greer's suggestion there is excellent. I think that modeling that beginning language is good, and we can give Mr. Hopkinson the flexibility to do that to make sure it conforms correctly. And I guess what we can do is basically, if there are any substantive policy considerations that turn up from that drafting, we come back to the committee and weigh through those and open the bill back up, or however we can procedurally do that, or a new draft and pass the new draft, whatever it is, in December, kill the old one. There's a few ways we can go about it. But I don't think we'll need you to.
Yeah, Senator Rothfuss, I don't know that we have to make it too complicated. We'll take that I'll take it as a conceptual amendment. I think that, and then you and I will look at the bill, and if we're still unsure, we'll have Representative Greer look at it and make sure, and Mr. Kaufman, that it was in line with their amendment, and we'll get it done.
Agreed. Thank you.
Okay, I like this amendment. All right, everyone clear on the amendment? All right, all those in favor, please signify by raising your hand. Okay, and those opposed? It's unanimous. Okay, we're back on the bill. Other amendments to the bill? No, seeing none, we'll go ahead and vote on the bill, and this will be a roll call. Mary Beth?
Mr. Chairman, this is a roll call vote on 21 LSO 160 version 6 as amended. Senator Dockstader.
Aye.
Senator Driscoll. Senator.
Aye.
Representative Greer.
Aye.
Representative Lindholm.
Aye.
Representative Yin.
Aye.
Co-Chairman Rothfuss.
Aye.
Co-Chairman Olson.
Before I vote, I should note that my my conflict, which I previously logged on this bill, is also no longer applicable, and therefore I can vote. So I vote aye.
Mr. Chairman, that bill passed.
That's unanimous. Okay, with that,
Great.
let's
Mr.
go ahead
Chairman,
and take a, what?
Yeah.
Senator Rothfuss.
Before the break, I just want to say great work, everyone. There was a lot of thought that went into this bill, and a lot of interim thoughts since the last committee meeting. Thanks, everyone, for really spending time working through these ideas, and those that weighed in and helped out. So good work, everyone.
Good job, team. Okay, we'll take a quick 10-minute break. We'll be back at 4:05. Please mute your mic.
So Chairman Rothfuss,
Yes, sir.
open-mindedness must have at least be worthy of a free beer if we're able to ever sit down together.
That is absolutely the case. You know, I will always buy you beer. And I appreciate it. I appreciate your work on that. I think that's a hell of a lot better bill coming out of that than we went into it with.
I wasn't able to get a hold of Greg. He was out of the office. I left a message, but I talked with Matt and dove into it a little deeper, and the concept of a supplement chapter seemed to and with the modifications from the last draft, I was like, this is fine. This
Good.
will be fine.
Excellent. No, I think it's a nice draft now. Now let's see if we can get something so clean for these next two bills, which are challenges. Although we won't take action on them today, I don't think.
Well, you're riding Mr. Kaufman like a rented mule. You know, most people have to pay.
At least
it's a true story. We're getting a good billable rate out of Mr. Kaufman, aren't we?
At least he said something nice about my hair. At least I think that was you. I can't remember who said that.
I'm getting a haircut before the Minerals Committee meeting. So. But I've got the same haircut. I just let it go about a half an inch longer after I got out of the military 30 years ago. That's all. I've just never been comfortable with that concept of using product, as my wife calls it. So I just.
If you keep it short enough, it doesn't need product. And it'll stay right where it started.
So yeah, Lindholm uses the what was the stuff they used in Brother Where Art Thou?
Yes.
Dapper
what
Dan.
is it? Dapper Dan. Isn't that right?
Yep.
Yeah.
That's good. I mean,
Yeah.
damn, look at that, right?
Dapper Lindholm.
Dapper Lindholm.
Dapper and Lindholm in the same sentence.
That's his new nickname, I think.
Happens more often than you think.
Yeah. Dapper Lindholm. Hi, Claire. Welcome.
So we're on digital identity, and Mr. Co-Chairman, this is your show.
Yeah. And Scott, David too. Okay, there we go. We got everybody.
But I will say we're not tracking too far off. So I will say, to the extent you can, accelerate it. I really like to end on time for these last two topics. But obviously don't cut our presentation short, but we've hashed through quite a bit of this. So for the presenters specifically, that if you've re-presented to us, you kind of have an idea of the things that we've heard and said, and try to get us to move forward with some new or different information. And we'll try to end on time.
Absolutely. Thank you, Mr. Chairman. And we do have a bill draft that we'll work through as our focal point. I don't have any intention of moving this legislation and working it today. This is the first cut, and I want to make sure we get feedback from all the folks that are our contributors here. Hear their thoughts on any ways we can change it and kind of talk through where it's at. So, Mr. Chairman, I'll have Mr. Hopkinson come in and talk through briefly, but as he's coming on, I'll say that there are actually two drafts that we have available to us. There's sort of the primary key draft here, which I'm just trying to pull it up right now, so I've got it in front of me. I had the alternate draft. There we go. So we've got 21 LSO 216 working draft 0.5, and then we've got sort of a B version of it. And the reason for the B version is it's very much the same language. It's just where in statute we put the language. And I had a discussion with Mr. Hopkinson about placement. the working group that we have assembled, that pretty much everybody's present here to join us today for discussion, had originally talked about putting the definition language as an amendment into Chapter 8, which were kind of some common definitions or as used in statute. So it would be definitive definitions that would go throughout the entirety. And you'll see that in the draft that we actually have before us, Mr. Hopkinson has it placed in the same new chapter or new article, I guess, that we're creating as the Digital Identity Act, so that people would know where everything was kind of the concept behind it. So I'm going to pause there and ask Mr. Hopkinson to briefly run us through this relatively short draft. There's a few considerations that we need to go through, and then we can take some testimony, have some discussion on what we've got here. So with that, Mr. Chairman, I'll yield to Mr. Hopkinson for a walkthrough for us.
Thank you, Mr. Chairman. I'm looking at 21 LSO 216 working draft 0.5 digital identity. On the first page of the bill, it's got section 1 there. It's just creating a new chapter, chapter 30, the Digital Identity Act, and Wyoming Statute 4030-101 on page 2 are the definitions section, which provides a definition for personal digital identity and a definition for organizational digital identity. Those are, the language there is for the most part what was presented to the committee with some tweaks that came about in the course of LSO review. The primary change you see is the term individual was changed for natural person. At the bottom of page 2, we start with 4030-102 acts through digital identity. And that language is the same, again, for the most part, that the committee has seen before with some minor changes. To go back to the definition section, and as Chairman Rothfuss touched upon, one of the reasons LSO, in looking at this bill, or in looking at the language and the location, there was certainly some back and forth internally about that, but primarily the thoughts on the location were related to finding it in statute. Frankly, Title 8, where the draft B version puts that language, is kind of specifically reserved for very broad definitions that really cover just about everything that might come up in statute. And the reality with that title is even amongst attorneys, I think the vast majority of them don't even know that that section exists. So practically, when someone's going through to find a definition, generally they're going to be looking in the chapter, in the section where the actual language for the statute is. And so that was kind of our office's recommendation for why we would rather, or why to change it into and have it in that chapter. The staff comment addresses a couple of other concerns that came up in our review, primarily dealing with the term self-sovereign, and generally the consensus is that is a term that would be much better off being defined in one fashion or another. So that's certainly for the committee to consider. And that staff comment outlines some other concerns. Specifically there at the bottom, we see whether or not including government agencies in a definition of organizational digital identity might have some unintended consequences. Generally speaking, there was some concern about just kind of the broad language. But with that said, unless you want me to go again through the specifics, Mr. Chairman, I would stand for any questions.
Mr. Chairman, I do have one before we get to other questions. The inclusion of governmental agency in organizational digital identity, I'm curious to explore a little bit what the discussions were among our attorneys as to, what problems that might get us into. I can see some upside and some advantage to having them there, but I'm curious what concerns were raised.
Mr. Chairman, I don't know that we really delved too deeply into that particular question. It was more a concern of the potential impact that could have. But as far as kind of going beyond the generalities and simply raising the issue, I'd certainly be happy to delve deeper into that issue for the committee. But right now, I don't have a lot of specific concerns beyond that general concern.
Great. Thanks, Mr. Chairman. And thanks, David. So with that, Mr. Chairman, I'll just remind the committee we have a working group that came together and spent a good bit of time talking this through. They visited with us a few times. So we have Dr. Claire Sullivan, Christopher Allen, Daza is here somewhere on my screen. There he is, Mr. Daza Greenwood, Brittany Kaiser, and Brendan Marr. And I thought we had one more, but I don't see him. So maybe he'll join us in a minute. And you'll see also, and again, I don't think we need to go through it in detail, but you've got an alternate working draft B, which simply places those definitions into the section that we originally had talked about. But as I talked about the draft when Mr. Hopkinson provided it, there was discussion that if we're intending to expound upon digital identity and start enabling the digital identity, that having all of the components of it in a single place in statute, in a single act, would really make that a lot easier, as well as having a definition section within that place in the act, so that if we do need to define, for example, self-sovereign or anything else, that we're not muddling, I guess, the other sections of statute, and that people would be able to link back and look those definitions up much more quickly. So what I envision with this drafting structure is that after the 40/30/102, which is sort of an overarching acts through digital identity, that we could have 103, et cetera, provisions at a later time, or even contemplate them for the upcoming session, some foundational ones that get more to the ideas that we've discussed about how to implement a self-sovereign digital identity, how to accomplish some of the own your own data type concepts, and that would be a place that we can put that type of statutory construct as we move forward and build off of it. So we don't have to do that now, but that's the idea of how this is drafted. So I'll stop there, see if there are any questions, and then we can kind of run the board on public testimony to provide some feedback and thoughts and concerns that our experts might have with these drafts.
Questions, committee, so far? No. Okay. Senator Rothfuss, who do you want to move to? Mr. Greenwood?
Thanks, Mr. Chairman. Yes, absolutely. Mr. Greenwood's got his hand up, and he's had the opportunity certainly to take a look at this. So let's hear his thoughts. And I know he has a few concerns that maybe we can address and talk through.
Okay, Mr. Greenwood, start by introducing yourself and then have at it.
Thank you very much. I just want to thank the committee members and everybody else at this hearing for the opportunity to speak to this revised measure and really to speak in favor of it. I've got a few comments on the draft itself. Based on the—
Sorry, Mr. Greenwood, sorry, just, it's a formality. I need you to introduce yourself.
Oh, excuse me.
For the record, please.
But of course, my name is Daza Greenwood, and I run law.mit.edu, which is a research tank and a teaching program at MIT in computational law and legal engineering. And I run the civics.com consulting company, and a long time doer in the area of digital identity. Okay, and so with that, let's see. The first thing I noticed in the redraft was that it didn't include the word control. And what I drew primarily from the discussion of the initial discussion draft in the last hearing was that that was really missing. And, I think that the introduction of the word self-sovereign may apparently have been an attempt to get at the notion of control, but I'd suggest that the best way to get at the notion of control is to include the word control. And so I'd like to suggest that the committee consider adding the word control. And I've got some ideas about maybe some ways to do that. But let me just quickly skip across at a top level the other major comments first. With respect to adding the phrase self-sovereign, that does strike me as somewhat ambiguous in this legal context, although there has been some history in technology communities and innovation communities around the idea. In a legal context, it's new territory. And so I share the opinion that the phrase itself would probably require a definition, and having a phrase that requires a definition in a definition may not be the best move. And so therefore it might be appropriate to not have the phrase self-sovereign in the definition of digital identity, or the two definitions for individual natural persons and organizations. Either that or to put some meat on the bone somehow, but I tried that a few ways and was unsuccessful. Specifically, with respect to the organizational digital identity definition, the word self-sovereign seems especially peculiar when applied to corporations and LLCs and other entities that are created and terminated by the state, which in our system has a dimension of sovereignty. And so really the sovereignty that is utilized to imbue life to a corporation lies not with the corporation, but with the state. And you can tell it because the state allows it to live and can make it die. And so, but if it were to include state governmental organizations, perhaps, but again, we come back to the question of what does self-sovereign really mean in a legal context? So moving on from the word self-sovereign, there's a change, as was noted from Legislative Council, from the word individual to natural person. I think that's a step up. It's a technical improvement. It's specifically what is meant. And the thinking in using the word individual was to really for a broader popular audience, but if what one's going for is legal precision, natural person is an improvement. With respect to the placement in the statutes, as I recall, in the last hearing and in side conversations, there was a desire to have a definition of digital identity that was broader and extended beyond trade and commerce, including civic activities, for example, and putting it in the section of the statutes reserved for trade and commerce is narrower, and therefore it may be better to have it as a general phrase, which can't, because digital identity is certainly coming up everywhere the statutes touches, and it may be very useful to have a phrase that can apply anywhere unless otherwise specified. However, this is obviously really a Wyoming decision, and I would view it as a major step forward, even if it were limited to the trade and commerce section. That would still be very desirable. So in closing, I just want to throw out there an idea for one way to include the word control, whether or not the phrase self-sovereign remains in the definition. And it gets to the part of the definition where we said of, by, and for. So what if the definition where personal digital identity or organizational digital identity means the intangible digital representation by, for, and under the control of a natural person, or the list of entities. So by, for, and under the control of. And that, of course, gets one finally, this is truly in closing, to some of the discussion that the legislative office was beginning to bring up about what does control mean? Are we talking about exclusive control, or like occasional control, or primary control? Or maybe in the context of the statute, control when it is determinative for purposes of attribution of an act to the entity that's being acting through its digital identity. These are tough questions, and it strikes me that the best course may be not to get into that level of detail. The word control is pretty good. I think it speaks for itself and can be applied as needed over time to the relevant factors. So to wrap it up, I suggest adding the word control. Thank you very much for your consideration.
Thank you. Adding the word control.
Yep, that's my slogan for the day.
Appreciate it. Ms. Kaiser.
Yeah, Mr. Chairman, I have a question.
Oh, I'm sorry. I didn't see you, Representative Greer. Questions for Mr. Greenwood?
Yeah, disagreement. Your comments on either of those, again, I think were helpful for me because Title 40's trade and commerce and the scope of this seems to be broader. And so when the Supreme Court interprets statutes, they have a tendency to assume that the legislature meant for something to be limited or cover as a result of where we might put it or a particular word we might use. And so I just want to say I thought those were good comments on it. And then I just wanted to ask you, you glossed over it, but it's a very good point. Our rules of attribution with respect to entities, and how do you, if you can articulate it, how do you see that being something that is legislated or protected or defined, or can it be?
Yes, thank you, Representative Greer. So with respect to the rules of attribution, I believe that they are very well defined in Wyoming statute and in the state statutes of the rest of the country through the Uniform Electronic Transactions Act, and that's directly reflected, like we tracked almost word for word to that formulation in the section before you now on digital identity. And just as a quick talk through of what it means, it's the best part of it is it just says acts are attributable to an entity if they were in fact the acts of that entity. And how do you know that? Well, we know how to prove things legally. You could go to a court of law and see, do you have relevant and admissible evidence that proves one of the, relevant, factors for whatever the case may be. There's a little more meat on the bones with respect to security procedures. And so if a security procedure is used, like to authenticate the information and the entity that sent it, like a digital signature, for example, that's not the only kind of security procedure that can accrue to create these are not the technically correct words, but like a greater presumption of attribution, or could limit defenses. But in general, I'd say I think that now you asked, how does it relate to organizations, I think was the specifics of the question, if I understood you correctly, Representative Greer, and you're nodding, let the record reflect. So the way I think it goes to organizations is functionally the same. And it's been many, many years since I had to litigate, but there were times when I had to prove a corporation was legally responsible for an act, like in a loan default case in particular, and I needed to basically show the evidence that the loan document originated from a particular entity, and that they had done some things that were, in that case, illegal. And so I basically showed who signed it. I showed some other context. It actually indicated the party on the loan document. This was considered adequate evidence. So I think, for the most part, these organizations obviously operate through individuals, and there's a big question about whether they were operating within their scope of authority and operating as an agent or on behalf of the entity. And there's other forensic evidence too, where you can see, does it come from that entity's systems and that sort of thing. But I think the processes for attribution of acts and communications to an organization are fundamentally similar to how we would attribute acts and communications to a natural person. Although I worry a little bit that I may be missing the point of your question.
So, Mr. Chairman, I don't know where you went on my screen. There you are. Yeah, and I guess what looking at within an organization, it seems as if you always have to jump through hoops to be able to provide documentation of authority in advance of the signature being applied. And I was just curious if there was a way that we could help speed that up. Because if I heard you correctly, you were telling me that if the act is done, then it's after the fact, you do the postmortem to see if it was appropriate or not, or if an issue arose with it. And I guess maybe I'm overthinking this myself. I don't know.
Mr. Chairman, may I offer one follow-up?
Please.
I think the answer is a definite yes, Representative Greer, that there are ways that would be beneficial to speed up and provide greater legal certainty with respect to when communications or acts are coming from organizations. I think some of this relates to being able to pin down the identity of the organization and to connect that meaningfully to the act or communication. I've only been lightly watching what you're doing with the Secretary of State and the identifiers for corporations, but I think some of this really comes down to having methods and mechanisms to link the identity, and then encouraging commercial best practices that do that as part of a workflow, like when you're doing the initial handshake or starting a transaction, that we look for this in the proposals and the back and forth. But right now it's really very relatively primitive. It's not so different than how it was in agrarian times. Like, we ask for these pieces of paper that show that you're duly incorporated, and we make these attestations that we're operating on behalf of that entity and stuff like that. And I think a lot of this can go away once we have digital identity of organizations that can be referred to, incorporated by reference, and then verified online, like at an IP address or something like that. My sense is a lot of this will disappear into the protocol layer, the way it does in a supply chain. Like, always know in a supply chain where transaction codes are coming from and to, because it's baked into the system, but that's a bounded context. When you get to an open context, we're going to have to rely on things like the credentials of a company And I think the state is a very good authoritative origin point to assert what those credentials are, and therefore to support and reflect them in transactions at the beginning, so we don't have to do all this churn and uncertainty later in the transaction. Or worse yet, what I was mentioning is when everything goes wrong and you have to prove it in court. That's actually the worst time to figure this out. What we need is preventative law. And I hope that this definition of digital identity is a key building block to get past those legal roadblocks.
Representative Greer says thank you. Other questions for Mr. Greenwood? Great. Well, thank you. I appreciate your comments from the legal and more technical aspect. Being able to marry those two together, in your opinion, is, I think, very valuable to the committee. So appreciate that. Ms. Kaiser.
Thank you, Chairman of the committee and committee members. My name is Brittany Kaiser. I'm the co-founder of DATA, the Digital Asset Trade Association, a Wyoming 501c6, where we work on digital asset legislation and lobbying. I would like to keep my testimony short, but I think I'd like to bring this back to the problems that we're really trying to solve with this bill. Or at least what my interests specifically are in creating this bill, which is that we're trying to make it easier for people and organizations to prove their identity in a digital world and have that be legally accepted. And we're trying to leave people's and organizations' most private personal data secure from data breaches by not sharing personally identifiable information with every organization with which you need identity verifications. So I think if we are looking at adding more definitions, which I think is a really good idea, that we need to get a little more technical. I'm not sure if I would recommend that we define the types of data that could be used for digital identity purposes, because I think that's going to be too exclusionary, but we might want to consider that. I definitely think it's important that we define self-sovereign, because the point is that we can we or as individuals or organizations would be able to provide enough sensitive data that we could prove our identity without that having to be verified externally in any type of way. So I think going into that definition is very important. And as a lot of the point of digital identity is not transferring that sensitive data and instead being able to use a password or a public key of some sort that can represent your identity. I think it's very important that we do include the word control, and Daza, thank you for bringing that up, because I think that's so important. Who owns the data that is within the digital identity, who controls that data? Because the entire point is that of self-sovereignty, and that it is your identity or your organization's identity, is that all of that data that verifies the identity is not actually technically shared. You're sharing with some sort of identification key or password, etc., and so forth. So I just think it's very important that if we're trying to do more than just get digital identity legally accepted in the state, and we're actually trying to cover our bases of what is the point of digital identity and the definitions that go with that. It's very important that we add control or ownership, define self-sovereign, talk about what we're trying to do, like not transferring PII and sensitive data that is usually used for identity verification. And that, that would make me a lot more comfortable saying that this type of bill is comprehensive. So thank you.
Thank you, Ms. Kaiser. Questions for Ms. Kaiser? All right, you get off the hook easy. I saw Mr. Mayor in here. He was defying gravity earlier, but now he is in sync with gravity.
Yes, I hope you all can hear me.
Yes.
Oh, wonderful. Okay, great. Yes, then for the record, my name is Brendan Marr. I am a MIT Media Laboratory alumnus, from 1995 to 1998. I'm a computer scientist. I have 2 corporations and a series LLC in Wyoming, and I'm a member of the computational law communities out of MIT and a mentor for the Lao DAO. I would like to continue along and address this extraordinarily important construct of control and embellish upon it because it is very, very important. Ultimately, we're not just talking about control of data, as Ms. Kaiser has expressed, but control over everything, computation, execution of algorithms. So it is very important to get this correct and right. When we're talking about identity and the word control, as it may be put into the statute, what I wish for everyone on the committee to consider in proposing the legislation is this, is that exclusive control does not necessarily always work, because what we were talking about in terms of identity is a conglomeration of different kinds of identities, basically roles. When you have a entity, whether it's a corporation or an LLC or any kind of entity, we all have our own individual identities and our identities as a part of the role of that organization. So exclusive control does not necessarily work if you just throw it in there into the statute as a term. You have to be a little bit more careful in terms of how you define exclusive control as it may relate to a DID in specific, or as it may relate to control over something that a key is bound to, an asset, an algorithm, et cetera, et cetera. So I'm happy to take further questions upon that. There's certainly more I can talk about on the topic, but this is important and I don't want to take more time than is needed.
Committee questions? I mean, obviously, I have the big question, but and that is, how do you carefully define exclusive control then?
Well, I think this gets towards the notions that were thrown about in the discussion with Representatives Driscoll and Mr. Greenwood in terms of attribution. We have attribution, we have different DIDs. We will actually have many DIDs per se that will compose identity. Right? So it becomes important to be able to prove that you have control over the pieces of that identity, those are DIDs, and be able to express and prove that you have control over those pieces, which is different than proving that you have control over a key in general and what that key may hold or control. So I am not exactly sure how you strike that balance, but it is along the lines of teasing apart the application of exclusive control as related to the parts that go into identity, as opposed to a key itself and what a key may control or operate over. I hope that was helpful. Maybe not.
Well, no, it's helpful. It sounds like we're going to flesh this out.
Okay.
We're going to flesh it out. And Mr. Allen, you're raising your hand. Do you have specific thoughts on control? Oh, you're muted, Mr. Allen.
Yes, but I'll save it for my the broader comment.
Okay. Okay. Would you like to make your broader comments?
Yes, please.
Okay. 1 second then. Are there any other questions for Brendan? Okay. We're gonna hold on to control as a topic, and Mr. Allen's gonna give us our broader comments and hopefully something more on control. But please introduce yourself, please.
Thank you, Mr. Chairman, select committee members. My name is Christopher Allen. I am with Blockchain Commons, an open infrastructure for blockchain and internet security company based in Wyoming. In particular, in regards to this bill, is that I 5 years ago coined the term self-sovereign identity and wrote up 10 principles for self-sovereign identity that have been, in use by the community, technology community, for the last 4.5 years or so, and have guided a lot of thinking and organizations and some nation states on this topic. The good news is that there is some consensus that this is the right direction to go. The bad news is that nobody's ever come up with something sort of less than the 10 principles to describe it. But I have some insights in that direction, so I'd like to share these with you. First off, I want to say I'm in favor in general with the direction of this bill, where we're going with this. I think the recent changes, getting a definition into place, et cetera, is we're making progress. The key problem, as other people have said and the LSO has written up, is what exactly is self-sovereignty. And I think the thing where I really need the help of the lawyers in the room is that self-sovereignty really does apply in the real world. We basically all have inherent dignity independent of our birthplaces, our lineage, our labels, just because we're human, right? We're natural people, as we're using in the document. In our physical world, we've sort of have a convention through the United Nations and through our Constitution and other things that a person's physical and increasingly their mental integrity, should not be violated or coerced. And just in general, that's kind of what it is to have dignity as an individual human being. But there is exceptions to that when we violate or coerce the dignity of others, right? That's always been a limit. If we're not harming other people or whatever, we ought to be able to have that integrity. Now, we also, as natural persons, have other rights. We have freedom of speech, we have assembly, we have association with who we want. Again, with the limits that, we don't use it to harm others, like crying fire in a theater. So the point of the 10 principles of digital self-sovereign identity was to try to bring those real world self-sovereignty principles to the virtual world. I mean, we have them in culture, in international law, in law of these basic things of, hey, but the advantage that physical world has is we have locality. We know exactly where that person is. We're in a virtual world, we're everywhere in a sense. So the point is that, we tried to come up with principles to keep that dignity, to create that, physical and mental integrity and not violate or coerce people through their digital identities. We tried to keep that in there. And where it became particularly challenging is in areas where organizations and governments have basically said, well, wait a second, digitally, we own you. We control the data. We, whether or not it's Google or North Korea, or China or whatever, they basically said, well, digital's something different. And our argument is that, as we move our lives increasingly in the virtual world online, we have to do this. So I really feel like there does need to be an effort to try to capture some of these principles, starting with, where did they come from in the real world? That human dignity and inherent right to physical and mental integrity, and figure out how to apply them online. Some early advice is don't start with principle 1, start with the late principles, start with 10 and then work back. I'd be glad to work with some attorneys on this, but I cannot do it myself. I can talk about why did we do that principle? Why is it, resonated over the last 4.5 years, how various states and whatever are doing stuff, but it does require some work diving in on this. So I'm here to help with that from the technical side, and as somebody who's been waving the banner of self-sovereignty for the last 5 years. Finally, I am not absolutely sure that self-sovereignty applies to organizations, or at least not in the same way. The individuals in a corporation, or and how that is how a corporation represents them in various ways, there may be some, but does corporation have a basic human right of dignity separate from that is granted temporarily by the state for them? I don't know, but I'm less concerned about that. I'm concerned about the individual digital identity. I'm definitely in the favor of the word control versus ownership. I think there are a lot of risks of ownership. You don't have the right to sell your body. You don't have the right to enter into servitude. You don't have the right to give away your kidney. So there are limits on ownership with our human selves. So I think in the same way they're trying to apply laws of ownership, and largely the online the digital identity community, and to a lesser extent the sort of legacy digital identity communities, are moving away from the term ownership to control. So I'm in favor of moving in that direction. So that's my statement.
Okay, Mr. Allen, there's maybe just to clarify this for the record, maybe you have a different opinion, I'm not sure, but I'm watching in our chat box, and there's some discussion about control, exclusive control, and can you flesh that out a little more in terms of your opinion on what is meant by control and what is necessary in terms of defining it within the statute or stating it within the statute?
Yeah, so architecturally, there's some answers here, which is we start off with being able to demonstrate that someone has, control of a key or control over something. That's why, we were talking this morning about, the private key and the care of that and custody of that. And then from that, we basically are consenting with other parties into sharing control or having exclusive control on various kinds of digital rights. So that's architecturally the way we built these newer architectures, is we start off with something that an individual can control, whether or not it's a Bitcoin account or a digital signature of an original work, a book, or things of that nature. And then we basically, just like in the real world, we entangle with each other in various ways. I think there are lots of interesting things around control in how assets work in the real world that are sort of independent of the ownership of them. And I think Claire may have more to say about that. I know that was one of her points earlier on that I think are very parallel. Now we need to tease them out a little bit. I have potential control over my parents' assets if they are in declining health and I have power of attorney. Does that mean I own them? No, I have control. Same thing with children until they're 18 and things of that nature. So I'm much more in favor of kind of looking at those types of things and seeing how we can apply those ideas of my responsibility as a controller and my limits of what I can do under control, rather than focusing on it being, oh, I can willy-nilly give it to anybody. I have some responsibilities when I have control. At least that's how I, as a non-lawyer, look at some of these things.
Okay, thank you. Senator Rothfuss.
Yeah, Mr. Chairman, based on the concept and the discussion that we're largely focused on the control idea, I'd ask, we can see if anybody has any questions, but I think going to Professor Claire Sullivan next and getting her thoughts on that would be useful, getting her comments in general, but also the exclusive control or how we would want to characterize control.
You read my mind, Senator Rothfuss.
I can do that. It's a trick.
Ms. Sullivan, please, go ahead and introduce yourself. And we do want, as the hour draws late, we need to try to focus our conversation. I don't mean to limit you, though. Please weigh in on the control issue, and of course, anything else. Just if it's already been said, try to skip over that, just so we can try to make up some time. We still have one more topic after this.
Okay, thank you. You hear me okay?
We can hear you.
Hear me? Okay, all right. My name is Claire Sullivan. I'm a professor at the Law Center at Georgetown University in Washington, D.C., and I run the CyberSmart Research Center there. My specialty is in the legal aspects of digital identity. So I just want to make an overarching comment. And I'm a little sorry to do this because I think I understand where people are coming from. I think it is a mistake to put sovereign identity in this legislation because it limits it. And I understand completely where Mr. Allen is coming from. But let me say this, just having a concept of digital identity in law is groundbreaking. There is no other jurisdiction in the world that I know of that is doing this. And just by doing that, other things flow from it. So the dignity concepts and the rights that Christopher Allen was talking about flow through by simply establishing digital identity as a legal concept. By putting the self-sovereign part in there, it's limiting it because many of our identities, our official identity, is not self-sovereign in that sense. It is an identity that's imposed on us. But even though it's imposed, we have rights that surround it, and we have there are obligations that surround it from governments, for example. So that's the first point that I would make. Just turning to the control part of it, the fundamental concept of property rights is based in control. So there's a principle that, and it goes right back into centuries old English law, that none of us own real estate, for example. It's all about our control and an exclusivity that centers around that. That's what gives us our rights to have what we call home ownership, for example. So I think there's a couple of essential elements that need to be in here. Control is one, exclusivity is another, and that's not in the legislation. It's an important concept. But I don't think we need to go down the road of the self-sovereign part of it. If I look at this legislation and I was to argue why it didn't apply, I would say that it didn't apply to my passport identity, it didn't apply to my commercial identity, because none of that is self-sovereign. And I understand why people want to have the self-sovereign in there, but you don't need it to have the rights. The rights flow simply from having the digital identity. So I hope that helps in a way forward.
Ms. Sullivan, I think there's a possibility you may have triggered every conspiracy theorist who is listening to this feed about landlord tenancy and whether we actually own our land or we just have control of it as a tenant. But that's a side topic. Side topic indeed. Any questions for Ms. Sullivan? Other than the landlord tenancy issue.
I had a question.
Yeah. Oh, well, Brandon, typically we only take questions from the committee.
I understand.
Okay. All right. You got let off pretty easy there, Ms. Sullivan, but don't run anywhere if you still have time to stick around with us, because as we move forward here, there may be something that surfaces. Okay.
Mr. Chairman?
Yeah, Senator Ruffus.
I think Mr. Diedrich also wanted to provide some comment on this as well.
Yes, Henning, please.
Thank you, Mr. Chairman. Am I to introduce myself?
Yeah, I know it gets redundant, but pretend that it's a written record and we have to figure out who you are each time you speak.
Thank you, Mr. Chairman. I'm a developer working in the blockchain space. I've been the first technical architect of the IBM blockchain, and currently I'm working on human readable programming language for smart contracts. I would like to keep it short and also fully support Sullivan. Does probably not mean how it is used in the draft. I would like to, it's an honor to be on the call here with Mr. Allen, who has coined the term, it seems, but it has become a fairly clear term as it's used in the community, and it has two parts. One of it is that it's self-controlled, and the other is that it's self-generated. And the way that the draft reads right now, it would in fact limit the digital identity that you were talking about to something that is self-generated, and excluding everything that has been assigned by an authority. And that's probably not what you want. And if you move forward and define the term self-sovereign in the way that you want it, then you would move away from what it actually means, how it's actually used in papers and in discussions and in the startup scene. That's what I wanted to add.
Senator Rothfuss.
Thank you, Mr. Chairman. Henning, to clarify, and I appreciate that comment. It kind of resonates with what Professor Sullivan was saying as well. It seems like if we take self-sovereign out of the definition, but then provide a lot of the self-sovereign concepts, perhaps in a later section, and we don't have to include it in the first draft, but maybe work on that at a later point, then we provide for more completeness, as I understood what you said, if I understood what you said correctly. Is that your thought?
Thank you, Mr. Chairman. So I would like to stress, and that's also, and again, support what Sullivan said. It's absolutely awesome to have self-sovereignty in there and allowing for it. That's the big step. It's just you don't want to make it exclusively only about self-sovereign digital identities. So I would leave the word in there if I was having a say, and make it that it's one of the possibilities how it can be created, self-generated, that is, and just not limited to exclusively only self-sovereign digital identities. And I think the discussion that we had in parallel is actually exactly the complementary discussion about talking about the control part, which probably you want to have as a fairly exclusive component in this, because you want to be sure that that's really tied and there's a responsibility, right? But I think it really makes sense to explore what Samaya has said, where we probably do not control all of the aspects of our digital identity for it to be useful. And that's something to be explored, where maybe it helps to think of it having two parts. One of it might be a digital number, for example, like blockchain address. And the other is what is stored and what we have added in data or assets that are controlled by this address. So that's two very different things. And the one we hopefully fully control, and the other we might not, because it's just a key to it. It could be a shared key and stuff like this. and there our control starts to be blurry. And that's what we were discussing in the chat box.
Thank you, Mr. Chairman. Mr. Chairman, I feel like we should have offered this as like a digital philosophy course or something. Had I known these conversations would be this good, we could have listed it.
I'm feeling you.
But I think we're pretty close. Sorry, Mr. Chairman. It's not like we should start the discussion from the top. It's fairly close. And it's awesome stuff.
Committee, any other questions? Weigh in. I think we were gonna, Ms. Long.
Thanks, Mr. Chairman. Just a quick point on this item of the definition of control. There is extensive language around that in the Speedy Bank legislation and rules that I think we could probably adapt. Thanks.
Great point. I know we were supposed to hear from Scott David, but I do not believe he's available. Mary Beth, can you confirm if he's no longer available?
Mr. Chairman, you are correct. He did have another call. He was going to try and get back into the meeting, but it doesn't appear that he has.
Okay, well, I am certain we will have one more, at least one more meeting on this. We know we'll have at least one more if we want good legislation. So we'll have to circle back and get Mr. David's comments on at our next meeting. Do we have other general public comment? We let some folks in.
Mr. Chairman, we did have a few people from YDOT sign up, I believe, on this topic. They decided that they weren't going to add any public comment, so you don't have anyone else.
Okay, and I saw that as well. Okay. Committee. To Senator Rothfuss, you said you do not want to take any action on the bill other than the Representative Lindholm action, which is to move it forward to the next meeting.
Absolutely, Mr. Chairman. I wanted to hear this discussion and see where the committee felt we should go. I sense from, and I'd throw this out there as far as putting a next draft together. It seems that there's a general desire to remove self-sovereign from both of the definitions in its current place. There seems to be a general desire to perhaps, I think Daz's language was specifically good about changing it to by, for, and control of, if I'm not mistaken, a natural person. And then we mirror that language for the next draft. And then I think the next thing would be, if we want to start some self-sovereign principle concepts as a section 103, we can do that. And then that would provide us with an opportunity to perhaps bring in some self-sovereignty concepts as an alternative, or if we want to stand here, that's something I'd kind of like the feedback from the committee, select committee on. And then the final thing I'd really like feedback from the select committee on for the next draft is between the two options that we have here, where we've got either putting it into chapter 8, in the general definitions for personal digital identity and organizational digital identity, or where we have it in chapter 40 in the working draft we have before us. So I guess those are the two decision points I'd like the committee to discuss and provide some guidance and thoughts on, if there is any. And then we'll get this group together during the next interim at least once, maybe a couple times, to hash these same discussions out. But I wanted that guidance from the committee.
Ms. Long.
Thank you, Mr. Chairman. I do believe we need to put the concept of self-sovereignty in the legislation for one simple reason, which is to make a statement that identity is not given to us by our government. Identity is something that is inherent to us as a human being. It comes from natural law. And if we don't address that, then the presumption is that the identity is bestowed upon us by our government, which I don't think any of us would agree with. Thanks.
Thank you. And Mr. Chairman, can we go to Daza briefly on that?
Mr. Greenwood?
Thank you, Mr. Chairman. I very much agree with Caitlin Long's comment about the importance of really throwing a gauntlet down about what the nature of this definition is supposed to be about. That identity within natural law that arises from the fact of a human existing. Yet at the same time, I really resonate with Claire's comments and others' comments about this phrase self-sovereign in the context of the statute at this time, because the phrase, I'm not sure if you would accomplish what you're saying or what we're saying with that phrase, and it may actually cause more problems than clarifications. And so I just wanted to suggest something that comes from somebody who's here in spirit today, but not in physical or digital presence, Elizabeth Ramirez, who certainly informed my thinking over the years on this concept. And we'd written an article once on some of these matters, and a phrase that we came up with to speak to this was universal, indivisible, and inalienable. But those three words in that combination, these have some history in law and jurisprudence, and I believe they get very directly and explicitly at the tradition of natural rights, and you could trace them to our Declaration of Independence and other sources that indicate the people as a population are the source of sovereignty. So I wanted to just put forward for the committee's consideration the, one, two, or all three of these words, universal, indivisible, and inalienable, as potential fodder for the definition to scratch that itch of defining that this is arising from a person by right, natural right, and not bestowed by another that can take it away.
Thanks. And Mr. Chairman, I think that's something that we can focus some effort on, is trying to incorporate self-sovereign, but not in the way we have it. And I think what I've heard loud and clear is that we need to include self-sovereign and non-self-sovereign components of digital identity in some fashion, where with the self-sovereign, we want to look to Christopher Allen's concepts, which I think reflect Mr. Greenwood's ideas of this universal, indivisible, and inalienable component of that digital identity. But again, that won't be all aspects of it. So we could potentially put that in a 103 section, or we could look at working on the definition. But one of the key concepts that I think the group has come up with over time is that we don't want to just load a bunch of things into the definition. We don't want a large, clunky definition. We want a lean definition, and then we can use other language, other paragraphs, other sections to provide attributes to that definition. So that would be my inclination. But anything else, Mr. Chairman, from the committee that the committee feels strongly about, wants us to focus on, or any decisions about how we should proceed?
Well, it sounds to me, Mr. Chairman, that it sounds to me like you may need to bring a couple different versions, because I don't know that there's a general consensus. I'm starting to feel like there's general consensus conceptually what we want it to be or say when we mean to say self-sovereign. And I think Ms. Long summarized it best, without getting deep into the Locke versus Hobbes versus Mill's philosophical thought. At the end of the day, there may be more than one way to say that.
Yep. And
I think if you bring to the committee even a couple different versions that we can agree on something, then I think that might get us where we want to be.
Yeah. Well, we've got good thought to.
And I think the same is, sorry, Senator Rothfuss, I think the same is probably true with control. I mean, if you can flesh something out, but at the end of the day, I think I am hearing a couple different things from some of the different stakeholders. So I think if you come with, you know, one or two competing ideas, I think that's okay that we flesh it out rather than rehash the conversation from beginning. I would be okay with that. Representative Yin.
Thank you, Mr. Chairman. I'll add my 2 cents in that I'm extremely uncomfortable with using the term self-sovereign unless we have an extremely tight definition, because, well, in some ways, because there is a sovereign citizen movement, and I worry that they would abuse our statute in some way if we put the term self-sovereign in our statute without giving it a strong definition. But I think ultimately the word control does enough in that aspect as a good first step. And if we want to put more principles of Mr. Allen's self-sovereign identity principles, I think that is a good way forward other than just using the term self-sovereign. So ultimately, I think I agree with Mr. Greenwood's proposal of just replacing it with the identities under the control of a natural person. And I would be happy to move forward with a draft that looks like that in the next meeting. Thank you.
All right. So we got one. It looks like we could very well have because you do have a bill.
Yeah, Mr. Chairman, and again, the bill is a good starting point. We've got 2 versions of it. I think I'd ask committee members and particularly legislators that are sensitive to location and statute if they have any preference of. And there's a third option, which is that we can do both. You can actually have the 2 definitions in Chapter 8 and then refer back to them from Chapter 40 as a pointer, effectively, and say for the purposes of this act, digital identity shall mean, and then refer back. And then we can add our own internal definitions as well. So I think there's 3 options there, and I just wanted to see if anyone has any preference, and we can talk it over and come to our own conclusion as well. But I do agree with, I don't remember who said it first. It might have been Mr. Greenwood, about the fact that we might be limiting our scope. And Representative Greer mentioned that the court will tend to interpret it based on its scope as well. So that was a concern that I'm sensitive to. So I don't know if anyone wants to weigh in more on that. We do have some guidance.
All right. If you have committee, if you have a strong preference, email Senator Rothfuss your preference. Representative Greer, unless you'd like to state it.
So with what Mr. Chairman, what Co-Chair Rothfuss is, I'm intrigued. I'm trying to think of where I've seen this before, but if it was in Title 8, which is a catch-all. And you know, when I was practicing, all else failed, I'd go and look, see if there was something in there. But the concept of a pointer coming out of Title 40 is intriguing, and I think worth maybe asking our LSO staff if that's something. Nothing's coming to mind where we've done that before on such a large, comprehensive definition. This is more than a definition. I mean, we do it a lot of times where we say, yeah, this means the same as back in a different title to tie it together. But I would look at, I don't know, Senator, if that was like your third option, but that would seem to be reasonable to me, is to try that.
Well, Mr. Chairman, I'll try and go with that then as a prime option, unless LSO kicks it.
Well,
you've got Representative Lindholm also seems to, based on the waving of his hands. Has a
Representative Lindholm.
Thank you, Mr. Chairman. I do enjoy towards the end of the day when Chairman Olson is the man in the saddle, because he starts getting a little tired and starts glazing over. I do the same. So
you should see what happens in appropriations when it's 11 o'clock at night.
That's why I sign up my buddies for that committee, and why I never win. Title 12, Chapter 49 seems appropriate if we're talking about self-sovereign, which it's funny to me that Representative Yen flinched on it. I kind of fist pumped on it. Title 12, 49 is the Wyoming Food Freedom Act. Makes good sense.
All right, Senator Rothfuss, that's where we're going to put it.
All right, there we go. Yeah, sure. We'll just refer back.
Refer back to food freedom.
Exclamation point. All right, I think we have our direction there. Unless anybody wants to throw anything else at us, we're in good shape. All right. Majority Leader Dockstader, did you have anything? Are you comfortable with that? Okay, perfect. Let's get to DAOs then.
DAOs. All right. This is you again, Co-Chairman Rothfuss.
Yes, thank you, Mr. Chairman. I'm going to quickly hand it over, though. We do have a bill draft. That was one of the things we promised, and we've got some conceptual case studies. Mr. Kaufman and Mr. Wright spent a good bit of time working on this to get it to where it is. It's an early non-reviewed bill draft, but I wanted to make sure that we had something to look at and talk through. So with that, I'd ask Mr. Hopkinson to give us a very quick run through since we're short on time, and then we'll get to Mr. Wright, Mr. Kaufman to talk about what we're doing here.
All right, Mr. Hopkinson, run us through the bill.
Thank you, Mr. Chairman. I'm looking at 21 LSO 263 working draft point 2. Staff comment there at the front just does, and as Chairman Rothfuss indicated, this language has not been reviewed by LSO, and that's just, we wanted to be upfront about that. And so it may require significant changes as it goes through our process. On page 2 is the start of the bill. Section 101 just provides a short title there. 102 is the definitions defining blockchain, decentralized autonomous organization, majority vote, and smart contract. Over on 103, we start getting into what the draft does. 103 simply provides that the Wyoming Limited Liability Company Act applies to decentralized autonomous organizations. That act essentially is the controlling act, and then what's in this draft, any inconsistencies, what's in this draft is what controls, and that it does not modify or change the Wyoming Limited Liability Company Act. Section 104 on page 4 provides a definition for what a decentralized autonomous organization is, clarifying that it's a limited liability company whose articles of organization contain a statement that the company is a decentralized autonomous organization. It provides that an LLC may convert to a decentralized, I apologize, I'm just going to start using the term DAO. That's easier, shorter than to keep saying that.
It's okay.
Do it.
To a DAO by amending its articles of incorporation, that they shall provide a statement in substantially the following form, and you'll see that statement on page 5. That generally provides that notice that the rights of members in a DAO may differ very significantly from the rights in a typical LLC, and outlines the way some of that may occur. It provides that in subsection D, that the registered name for a DAO shall include specifically DAO, LAO, or DAO LLC for an abbreviation. It shall include a statement in the articles of an organization that specifies that the organization is either a member-managed DAO or an algorithmically managed DAO. And if there is no specification, it will be presumed to be a member-managed DAO. Section 105 on page 6 provides that any person may form a DAO by signing or delivering an original and one exact or conformed copy of the Articles of Organization to the Secretary of State, and that the person performing or forming that company need not be a member of it, and that each DAO shall maintain a registered agent in Wyoming. 106 specifies the Articles of Organization and provides that the Articles of Organization of a DAO shall include a statement that the company is a DAO, that the Articles of Organization include a publicly available identifier of any smart contract that's directly used to manage, facilitate, or operate the DAO, that except as otherwise provided, the Articles of an Organization and smart contracts will govern all of the following: govern relations among the members as members, between the members and the DAO, the rights and duties under this chapter of a person in their capacity as a member. Now we're over on page 8. The activities of the DAO organization and the conduct of those activities, the means and conditions for amending the operating agreement, the rights and voting rights of members, transferability of membership interests, withdrawal of membership, distributions to members prior to dissolution, amendment of the Articles of Organization, and all other aspects of the decentralized autonomous organization. Section 107 provides for the amendment of the Articles of Organization, that they shall be amended when there is a change in the name, when there is a false or erroneous statement in the Articles of Organization, or the DAO's smart contracts have been updated or changed. Section 108 provides that a smart contract excuse me, provides that to the extent the Articles of Organization or smart contract does not otherwise provide for a matter, that the operation of a DAO may be supplemented by an operating agreement. 109 provides that the management of the DAO shall be vested in its members if it's member managed, or by the smart contract if it's an algorithmically managed, unless that something otherwise is provided in the Articles of Organization or operating agreement. Section 110 provides standards of conduct for members and managers, and provides that unless otherwise provided, no member of a DAO shall have any fiduciary duty to the company or any member, except that the member shall be subject to the implied contractual covenant of good faith and fair dealing. Section 111 provides that members shall have no rights under Wyoming Statute 1729-410 to inspect or copy records of the DAO, and the DAO has no obligation to furnish that information if it's available on an open blockchain. Section 112 provides for the withdrawal of members and provides that a member may only withdraw from the DAO upon the terms and in accordance with the terms set forth in the Articles of Organization, the smart contract, if applicable, or the operating agreement. If there are no terms and conditions set forth for a member-managed DAO, then a member may only withdraw with the consent of the majority vote of the members. A member of the DAO may not have the company dissolved for a failure to return his or its contribution to capital. Section 113 provides for the dissolution and provides that a DAO shall be dissolved upon the occurrence of any of the following events: when the period fixed for the duration of the company expires by the majority vote of all members, or at the time or upon the occurrence of events specified in the underlying smart contracts, or as specified in the Articles of Incorporation or Operating Agreement. As soon as possible, provided following the occurrence of any of those events triggering dissolution, the company shall execute a statement of intent to dissolve in a form prescribed by the Secretary of State. Section 114 provides that the Articles of Organization and the operating agreement of a DAO are effective as statements of authority when the underlying Articles of Organization and operating agreement are in conflict, the articles of organization preempt any conflicting provisions. When the underlying articles of organization and the smart contract are in conflict, the smart contract will preempt any conflicting provisions of the articles of organization. Section 2 provides for an effective date of July 1st, 2021. And with that, I would stand for any questions.
Any questions on the bill draft itself? Obviously, it is very much a draft. Okay, thanks, David. With that, let's yeah, go ahead, Senator.
Yeah, before we get started with Professor Wright and Mr. Kaufman, I just wanted to thank Professor Wright and his students and all of the ridiculous amount of effort that went into this by him and by them, as well as I believe we've gotten UW Law School students involved, and the law school is starting to get engaged. So again, we've got an incredible team that has been working on getting this ready based on our drafting guidance that we discussed over the last couple of meetings. And I think this really gets to what we were looking to achieve. So I look forward to the discussion today. And if there are any criticisms, anything that we can do better, looking to folks that have been practicing in this space, like Representative Greer, let's try and identify those for the next meeting. But this is a great product we have before us today, I think.
Great, thank you. Professor Wright.
Thank you so much, Co-Chairman Olson, and thank you so much, Co-Chairman Rothfuss. It's really an honor to be before this committee again. As noted and as David just went through, we've put together a draft, and it is very much a draft, supplement to the Wyoming LLC Act, which we think is at least worthy of consideration. I think, as everybody here knows, Wyoming has had a long history of innovation when it comes to corporate law, and we believe that this proposed bill, as refined, really can cement Wyoming's lead here and legally recognize DAOs through the passage of not an amendment to the LLC Act, but a supplement. As we've discussed in previous meetings, DAOs are really a new way that people want to use to organize their personal and business affairs, primarily using software-based systems instead of just legal agreements. DAOs have certain benefits, and we've been preparing a report which outlines that in detail, along with an executive summary, which we are hoping to circulate to this committee and for public consumption shortly. But they do enable the rapid pooling of capital, streamline group decision-making that makes things like voting and proxy voting more efficient, and potentially greater levels of control over organizational assets, which I think are huge advantages over what we have today. This is a space that's growing rapidly. Over the past couple months, there's been upwards of $300 million managed by these organizations, with over 10,000 people participating in it globally. So we're seeing an incredible uptick in interest from the public. And we're seeing, a different emerging DAO landscape, and what we try to account for in the supplement, both member managed DAOs, which are highly participatory, democratic, and algorithmically managed DAOs, which is something that's a bit more nascent, but defers to actual software-based algorithms to order human affairs instead of more democratic and participatory processes. There's a number of examples here. There's, as one example, Lao, which is a member-managed fund, or what you can think of as a member-managed fund structure that's limited to accredited investors, that has backed over 30 projects in the blockchain ecosystem. There's projects like Moloch DAO, although it's not the best named DAO. It is a grant-giving DAO that provides funding to software developers and has administered millions of dollars to it. And then there's larger projects like MakerDAO that are really trying to govern open source projects by creating stable assets and creating organizations that are managed by an ecosystem of community as opposed to a central authority. The issue, as we've described previously, is that many DAOs lack legal recognition, and thus under US and Wyoming law would be considered imply general partnerships. That means they lack the benefits of formal legal recognition. They lack the ability to easily transact with other parties and entities, and they don't obviously enjoy the benefits of a limitation of liability, which limits who can participate in these entities responsibly. Some DAO projects are forming as LLCs to enjoy these benefits, i.e. they're forming what folks are calling LAOs, but they're expensive. They're not a perfect fit, at least under the current Wyoming LLC Act, due to the fact that some of the default rules, the off-the-shelf rules, are not perfectly contemplating kind of these software-based arrangements. And some, DAOs are organizing under other states' laws like Vermont because they passed the BBLC. The proposed supplement is really designed in a way that we believe is sensible. It balances the need for transparency with DAOs with the promise of limited liability. With the passage of the supplement, we believe that Wyoming could build up upon its innovation with the LLC and help enable DAOs to flourish in a responsible way. Critically, the supplement does not alter the Wyoming LLC Act in any way. Rather, it is just that, a supplement. It's something that folks organizing a DAO can opt into. And specifically, just to kind of walk through at a high level what we were aiming to do here. Number one, we wanted to make it clear that people would be able to form a DAO and name the organization with DAO, LAO, or DAO LLC. We wanted to make sure that any of these organizations would be identifiable, but through service of process or by the state. And we require that a DAO register with a Wyoming registered agent, even if it's organized within someone from the state. We think that that's sensible, in part because we want to make sure that people who organize these things can interact with the traditional systems that we have in place. And we do think it's sensible to have a registered agent, particularly if these organizations are assembling folks from around the country, if not around the globe. We also wanted to make sure that the public can understand the operation of DAOs. So part of the bill really contemplates pulling some provisions that many folks would put into an operating agreement today into the actual articles of organization to increase transparency. So if it's necessary and if people want to understand what a DAO does, they have a document that is publicly available, which identifies things like the smart contracts used by the DAO, and also some core other provisions that may deal with its governance. So we kind of view the articles of organization as being the core document, which contains any provisions related to the DAO's operation, and again, is publicly available and transparent so that it can be identified. Our sense is that the folks that are putting together these organizations, since they're hoping to do it in a more transparent way, both by using blockchain technology and otherwise, that this will actually achieve kind of the public purpose of what we should do, which is force transparency and also make sure that people understand what's going on. But it also softens it. We understand that there should be some flexibility there. So to the extent that there is some private ordering that's necessary, folks are able to do that through an optional operating agreement. Critically, with many of these DAOs, it's not viewed as a really tight knit relationship between other members. It's really, I think, for most of these DAOs, a relationship that folks want to interact with at arm's length. And so that means that we varied the default rules relating to fiduciary duties owed by members of the DAO to one another, limiting them to just preserving obligations of good faith and fair dealing. Obviously, again, this can be varied in the certificate of formation and operating agreement if folks so decide. We also provide a set of default rules to govern issues related to amending the articles of organization and withdrawal. And in some subsequent amendments that we've been working on over the past couple of days, we've also addressed issues related to disassociation, addressing issues related to lockups that may happen if votes can't happen, and also pruning DAOs if there's no activity for over 1 year so that it limits any burden on the Secretary of State or otherwise. We also provide some clarity about what is going to govern, whether it's going to be the underlying software or the articles of organization. And there we make clear that the code will govern, which I think is the real spirit of what people want to do. But if there's a conflict, and it needs to be a direct conflict between the operating agreement and the articles of organization, articles of organization shall govern. The last piece, because and only to the extent that records are actually maintained in an open blockchain as defined in other parts of the Wyoming statutory scheme, we relax some of the need to actually provide that information since it's publicly available. So it's only limited again to if that information is publicly available, but we do think that streamlines that quite a bit. So we believe in that this is a supplement that's worthy of consideration. In our view, it aligns with Wyoming's efforts to lead U.S. corporate law, which in my humble opinion, I think there's no question there. It takes steps to protect the public and enable DAOs to interact with the state and other entities. It does not modify the LLC Act in any way. It, again, is a supplement. And I think critically, it enables people to order their affairs as they see fit, whether that's using new things like software or more traditional approaches like through legal agreements. So we hopefully will continue to iterate on this supplement with feedback, and we'll be submitting to the committee, if they allow us, an executive summary and a report that details all the provisions, provides case studies, and provides a more detailed overview of the proposed legislation. As Co-Chairman Rothfuss just mentioned, I just wanted to thank the folks that worked on this, including Kyle Bernowski and Zach Salzberg from Cardozo Law School, and also Matt for his feedback along with the students from the University of Wyoming Law School. We really appreciate it and hope that this is a first step in the right direction. Thank you.
Well, cool. Comments or questions for Professor Wright? Majority Floor Leader Dockstetter.
More of a comment. I think as we move this legislation through on both sides of the building, that we let people know how the university was involved, the law school. I think that's a good point to emphasize as we take this all the way through the process back on the floor. Should we make it back to the floor?
Yeah, that's a great point. In fact, it'd be really cool if we could get a couple of those students, at least from the University of Wyoming, maybe even some of the students from New York to virtually testify. I'm not sure how all that would work, but it'd be pretty cool to have some of the students weigh in on how they contributed and what that process was like. So that does sound like a good idea. Mr. Kaufman?
Mr. Chairman, I don't know if you were being prophetic, but we did invite a few UW students to testify, so they're here today.
Aha. Aha. No, but I meant when we get in front of the whole legislature, I think that'd be pretty cool. And especially there's nothing, it's one thing because it's Zoom, but there's just nothing like sitting inside the Wyoming Capitol and testifying on a bill inside the Wyoming Capitol. So that's a pretty cool opportunity.
Mr. Chairman.
Yes, please, Senator Rothfuss.
Thank you, Mr. Chairman. I do have one question on kind of bill content and how things would move forward. The dissolution was one concern I had. Sounds like you're already tackling that. Another concern, though, and you talk about when code's in conflict with the articles. I was just sort of curious how it would play out. I mean, if the code entirely went off the rails and failed, and they had just done an awful job of it, whether that's code underlying the articles or whether that's just a catastrophic failure in the operating regime. Do we have some sort of backstop in place, whether that's conceptual at this point or whether it's statutory, to provide some type of human cleanup when that's necessary? How would that play out?
Professor Ray, go ahead.
Co-Chairman Rothfuss, that's a great question. So number one is a supplement. So, and Matt, correct me if I'm wrong, but the entire Wyoming LLC Act, along with the supplement, would serve as the backstop. So that would provide the default rules. If that's a concern, they can also be addressed in the Articles of Organization and/or an operating agreement to provide that backstop as well. The last thing that it's not in the bill that's in front of you, but I think in an amendment, you'll see this. If there's no activity related to the DAO after 1 year, it will be automatically dissolved. And I think that that's important to prevent some of these types of lockup related activities. So if it went completely off the rails, and I know that there's probably different ways that things can go off the rails, but at least in the sense that it's no longer operational, that people can't use it, then it would be automatically dissolved pursuant to the law. But Matt, I don't know if you want to add something.
Go ahead, Matt.
Yeah, Mr. Chairman, thank you. And thanks, Aaron, for that response. Yeah, Professor Wright's exactly correct. I mean, I think again, just as a reminder to everyone, the underlying LLC Act generally defines two types of LLCs, member managed and manager managed. And so it's correct that the DAOs are designed, first of all, to only be member managed. You can't really opt in to be a manager managed DAO. And so, yes, the statutory structure would act as the default. But even more still, I guess, in the event that somehow the code broke down or was somehow in conflict, Professor Wright, again, is correct. We have both the supplement and the act to form as a backstop.
Great. Thank you, Mr. Chairman. That's all the technical questions I had for today. The other ones, I think they already addressed.
All right. Seeing no other questions for Professor Wright and Mr. Kaufman, are you going to bring in those UW students? You want to bring them in now, or what point do you want to bring them in?
Mr. Chairman, I have admitted Hunter and Todd into the meeting, and they are available whenever you are ready.
Okay, so we have Mr. Allen. We have Mr. Allen. Did we get Ms. Reyes back?
Mr. Chairman, she had a family commitment.
That's right.
So no.
Okay.
And
Well,
I think Henning also was going to provide public testimony, but that's the extent of our public testimony, I think.
Okay. Well, we want to end on a positive note. Not that Chris or Henning, your testimony won't be positive, but I'd prefer to end on the college students. So I'm going to go to you, Mr. Allen, and then I'll go to Henning, and then we'll make sure we end on a good note.
Okay, thank you, Mr. Chairman. Again, my name is Christopher Allen with Blockchain Commons. Something kind of fits in with a lot of discussions today, a Wyoming for-benefit LLC. So I am, basically already using the laws of Wyoming and whatever to try to do both benefit and some of these algorithmic type of things. So first off, I want to say and commend the team that have put together this draft bill, and I am heartily endorsing continuing and polishing and getting this out this session. I think it will allow for hundreds, if not thousands, of companies that wish to do some of these types of functions to fall under Wyoming law. I have a couple of specific things that I would love the writers to kind of look at and be careful about. The first one is the use of voting. Right now, there are 2 mentions of voting in there. A lot of the variations, especially non-Ethereum contract variations, use blockchains for the voting side of this work, and it's not really clear from the definition of smart contract that voting might happen in the smart contract. There's also some transparency requirements around voting, especially given, as people have talked about, things going off the rails or whatever. There may need to be some party to track the voting, in particular who voted for what may be confidential, but may be needed to later on to dissolve the company or to give the assets back to the various parties in case of dissolution. So I strongly encourage you to take a look at the smart contract definitions and voting and whatever, and integrate them a little more tightly and deal with the fact that some of these things may need to be escrowed by the registered agent or whatever to allow some of the things to happen. Also, like there is a thing where the smart contract has to be listed in the articles of incorporation, but sometimes you can't do it in that order. You have a catch-22, so make sure that that can be an indirect, say with a DID or something of that nature, because you may not be able to put the smart contract into the articles of incorporation until the corporation already exists. So that's the end of my technical comments, but hurrah, thank you very much for putting this together. Thank you.
Professor Wright, did you have something to respond?
Thank you, Co-Chairman Olson. Chris, I think those are great comments. Just one point, we did reference just that it needs to be an identifier to those smart contract. And then we did try to align the language at least to the previously adopted definitions for smart contract, but if there's anything that needs to be adjusted there, obviously happy to do that.
Thank you.
Any questions for Mr. Allen? All right, let's jump over to Henning.
Thank you, Mr. Chairman. I'm a programmer. I've been working as a consultant in blockchain things for the European Commission, for BCG, for IBM, for Temasek, one of the Singapore sovereign wealth funds, and particularly now I'm working on a human readable language for smart contracts. And that's the first thing that I wanted to mention, that reading this draft, it might become confusing when what I think very soon smart contracts will be programmed in a human readable form, which means that the charter of a corporation can actually be the smart contract itself. So then at that point, you don't have a difference anymore between the smart contract and the agreements that govern it on the legal side, and would be advantageous if that is not confusing with this newly crafted bill, obviously. So that's one point, to reread the draft basically and imagine that smart contract and the charter are the same thing. And does it then still make sense to make it future proof? The other thing is that let me try to put a metaphor. I mean, a judge and a court can change the truth, right? It can throw out a contract and can say, yeah, that should never have existed at all, or it can go and invalidate the existence of a corporation even, or the existence of the board. It can go really far in what it can mandate how things should go on or should always have been interpreted. But there are limits, and let's say if there's a satellite in space, a judge will not order the satellite to stop orbiting, right? It's clear that that doesn't really make sense. Like if the satellite is up in orbit, maybe a judge could order somebody to take it down, but they will not pretend that they can just stop it right there. And a DAO famously has this, or can be programmed to have this propensity that it has this unstoppable quality, like a machine that cannot just be stopped in its tracks, not even by a judgment, not even by a court order. And the more you clarify this, I think, in the draft, in the bill, that there is a quality, and then the DAO is allowed to have this quality, and what the limits are within which the DAO can have this quality, that it becomes unstoppable. And it is also clear that a judge will not be able to stop it, and that doesn't make it illegal from the start, which includes, of course, this question about what happens if something goes completely wrong. And the more you have the courage to actually allow it to go completely wrong without saying, well, we have the default laws that will always stop it, because that's what it's all about, right? You will not be able to stop it. That's its great quality that it has. And you might not want to allow it for every single aspect. You might want to decide that you propose very harsh conditions about, like in the extreme, you would like order it to have a backdoor to everything and anything. Then you don't really have a DAO in a certain sense, right? So you want to navigate And maybe you want to clarify in what sense it can be unstoppable and in what sense it cannot. And that might make for a more powerful, because of its clarity, because wherever you put the limit, you will still have a very interesting new creature created. And that goes to my final point, which is about the distribution. I think there's a poll, or there was a lot of blockchain cryptocurrencies out there are still being traded, but don't even have a project behind them anymore. It's just nobody cares. Like, they're still being traded, they still have value. They will never have a blockchain, really. They're just ERC20s, whatever it is. And you will have failed DAOs. And they might have started being LAOs under Wyoming law, but then something went wrong. The mechanism will continue to exist, though. And you might want to address what happens with these things. And that might actually be a legally new state, because it's kind of a new, it's kind of a failed company that might be dissolved to the extent that it can be, and human beings might not be interacting with it anymore, at least not as it was intended in the beginning, but it might still have customers. It might still have economic activity because it's programmed to do stuff. And even if 90% has gone wrong, it might still do 10% right, and it can't be stopped. And that's not really something you want to think about, because ideally law should trump technology, except in startup world, it often doesn't. And you might at least think about what should happen with, or what the status is supposed to be for these kind of zombie DAOs, because I'd almost guarantee you will have some of them. And it might not be from bad intentions, but there will be the question at one point what status it is that they have, because it is going to be somewhere between liquidated and dissolved, or in some legal limbo is where they're going to exist. That's my comments to this at this point. And congratulations again. I mean, it's super exciting stuff. Congratulations for this panel to put this all on the track, and for Aaron to bringing it up to this point, and to the team of students. That's great. That's really, I would say it's historic stuff, to be honest.
Professor Ray.
Thank you, Co-Chairman Nelson. I think those were really important comments. I will say that there's a bit of a distinction. So yes, even though the smart contracts underlying the DAO may still be in operation, it would not be a legally recognized limited liability entity under the statute. So if something goes sideways, if there's no activity, at that point, any of the remaining members would just, would either be dissolved if there's no activity. If it's still in operation, and somehow everybody's withdrawn, and maybe new people join in the future at some point, it would not be considered at that point just a legally recognized and a validly formed entity. So the software may still exist, but it doesn't mean that the entity would exist under Wyoming law. At least that's how it's contemplated. I think that's just one thing that at least we were thinking of here.
Mr. Chairman, I want to follow up on that.
Senator Rothfuss, please.
Thank you. Henning's thoughts, though, they do kind of lead you to wonder about circumstances other than just it stops operating. Well, it stops operating, doesn't make any contact for a year. Okay, that's sort of an easy circumstance to identify. But getting to what Henning's saying, where it starts doing the wrong thing, but it keeps doing it well, or you've lost control. We were talking about control before. I don't know that you want control over every DAO, but maybe you do. And I guess this gets into the question: at what point, other than it stops contacting, do you consider it a failed entity that no longer meets what we're going to put into statute as the bar that it has to achieve to be an appropriately recognized limited liability type corporation? And I think we need to think that through to get to what Henning's talking about, because I think there'll be other circumstances at which we don't want to provide that limited liability protection because it's not doing what it's supposed to be doing, if that makes sense. So, maybe we need to be more thorough in capturing those events and those circumstances so that we get to Henning's, zombie DAO apocalypse kind of concept where we've got strange things happening that weren't intended, but it's still doing stuff.
Professor Wright.
Thank you, Co-Chairman Wilson. Co-Chairman Rothfuss or Senator Rothfuss. I think that's sage advice. I think we can look into that. I guess one, again, backstop would just be the LLC Act. So to the extent it was doing things that were not, for some lawful purpose, my understanding, and Matt, you probably are more the expert here than I, but either the Secretary of State or other folks could dissolve the entity, I imagine, if we wanted to make that express or make clear that it needs to be for a lawful purpose in some capacity to gain legal recognition. I'm sure we could work on some tightening language there.
Mr. Kaufman.
Yeah, thank you, Mr. Chairman. And I just wanted to clarify that was part of the rationale already, at least in the thinking of the inactivity, which we don't really have existing right now in statute for other entities. I mean, we have a mechanism where if entities fail to file annual reports or do their due reporting, they can be administratively dissolved by the LLC. Although candidly, that creates really gray questions of law with respect to what that means legally for people when they're transacting with those entities that have been administratively dissolved. And so, agreed, Henning's comments are very well taken. And that, I think, again, that was why this concept of dissociation and dissolution are so tricky in this context, because what if you do have one of these entities that's acting in a way that people didn't originally want, or they don't want any longer, and you have members sort of withdrawing from their interest or their activity in it? They're legally dissociating, but it doesn't mean the entity itself stops. And so what we started to think about, and I think we do have some ideas, is that there might be some trigger points on this, that once you have a certain number of people dissociate or a certain amount of time. So I think we can create some fail safes with respect to the legal entity, but that doesn't answer the coding question of, what happens to this software that continues to run. But I think we can answer the legal questions at least.
Mr. Kaufman silenced the room. We do have additional public comment. I don't want to stop the train of thought, but if there's nothing additional on the train of thought, I'll move to some more public comment. Okay, Mr. Marr, you're on deck.
Wonderful. Can everybody hear me? Great. My name is Brendan Marr. I'm an MIT Media Laboratory alumnus, and I am a computer scientist. And I wanted to give a comment further on the discussion that we just had previously regarding computability that runs afoul. So first off, it's important to consider that I'm in favor of the legislation as it is put forth at this time. Obviously, it's a draft, but I believe it is a tremendous step forward for the future of work, and has many, many benefits that far outweigh the possible negative points that are being discussed. We will have to address these things. There is no doubt. And it gets to broader issues about automated and autonomous entities, automated autonomous legal entities, and machines and robots. These discussions are not going away. In fact, they're becoming more pronounced. So we will have to revisit these things, but these are a very good step in that direction. Regarding the idea that you would have these algorithms that would run away, the important thing to consider here is what has been stated, that they wouldn't be running away legally. If the members leave, if parties leave and no longer want to participate in that organization, it's not deemed viable. And that's an important first step. It's no doubt that we will have to have further amendments, but we're going to have to grapple with these issues with autonomous cars and robots and all sorts of things. So as it stands, I do believe that this is a step in the right direction, and the opportunities and benefits for providing a whole new economy is something that needs to be taken into consideration at this time. So I'll leave it at that, unless other people have other questions.
Questions for Mr. Moore? Thank you, Mr. Moore, as always. Appreciate your insight. Mr. Henning, Henning.
Thank you, Mr. Chairman. I wanted to, I fully agree with Mr. Maher, but I wanted to say, as a programmer, if you create rules, any rule might be helpful to then allow for programmers to program the DAO in a certain way, knowing that a certain threshold, and that might be a trivial, concrete number, is crossed, then the whole thing stops becoming illegal law, right? So I would encourage just to make courageous decisions to do it this or that way, but be clear about it. And that is going to help to for programmers and also for founders to set these DAOs up that in a way that they can conform, because it's clear what you have to do, and that they even can provide for the extreme cases and can build in self-destruct elements or whatever it is, so that they can try to keep within the limits that you set. But the clearer you go about it, the better. And obviously, liquidation of companies is ending a company, dissolving a company is always involved, even without a DAO included, right? And spelling this out will also just help for programmers to be able to actually put the provisions in place to minimize the gray area. Thank you.
Senator Rothfuss.
Thank you, Mr. Chairman. To Henning's point, the challenge I see there, I mean, I have this inclination to put in some requirements that DAOs have, certain coding facility, so to speak, that would provide the functionality that you're discussing, like some sort of thou shalt have as part of your DAO, which includes if it's going off the rails, some code to cease activities or something like that. But the challenge we have from I think a governing standpoint is there is nobody that could check that homework, right? We just can't. So how do you have any ideas on maybe what types of things we could say that could be reasonably effectuated, where we could have some confidence that we get a good outcome, but at the same time, nobody at the Secretary of State's office is going to be checking to make sure that the code will work at the end of the day and achieve it.
Henning?
Yeah, thank you, Mr. Chairman. I think it helps to think in extremes, right? In the extreme, you would mandate that that all the code have a backdoor and the key to it be delivered to the Secretary of State, right? But then you don't have a decentralized, then you don't have a real DAO. You might want to define those areas, though, that do have to have this backdoor versus those that do not have to have this backdoor. And I would hate that. I mean, just having any backdoor in there is not a real DAO then, right? But you have to have some sort of control through which you can then also allow those things that are truly decentralized. And in that sense, if you think about this nuclear option of just requiring there to be a magic central key that has to be delivered to the Secretary of State, whatever it is, and allowing for complete autonomy, knowing that you by this give up any chance for actually stopping something that runs amok. I think that just should be a conscious decision there. And I think there is no perfect answer, but the clearer you decide which how much freedom you allow there, the more powerful is the new option going to be that you are making possible with this law.
Professor Wright.
I was on mute. Sorry about that. Thank you so much, Senator Olson. I think that there's just a couple of things that are.
That was a demotion.
Co-chairman and Senator Olson, I apologize. I think there's a couple of things that are being slightly conflated here. So there's regulating smart contracts, which is not, I think, it's a very complex question, probably even more complex than some of the questions I heard earlier when I tuned in for digital identity and other areas along those lines. And then there's the question of legal recognition. So many of the blockchain-based systems, as I'm sure many of you are aware, particularly unopen blockchains, once the code is up there, it can be interacted with by folks, and there's not a tremendous amount that can be done. If you wanted to limit legal recognition to smart contracts that had a degree of control, I think there's more command and control approaches, which I would strongly dissuade. I think that's deeply concerning. I don't think that's in the purview of what governments have the capabilities and facilities to do. If there was a softer approach, you could either wait till you see something that is more concerning and address the risk at that point in time, which tends to be, I would argue, the prudential American approach to things, which is waiting to see the risks when they manifest. Or two, you could also prescribe, at least for algorithmically managed DAOs, that they're upgradable in some capacity. If they're upgradable and something goes, in a direction that's unintended, either the Secretary of State would have the ability to dissolve it, or it could be upgraded to address that issue. So it wouldn't go down to the core, which is not the substance of, I think, what we were intending, which was regulating how smart contracts are developed. Instead, it's recognizing that if people want to get together and organize their affairs using this tool, the smart contract tool, they shall or have the ability to get legal recognition, assuming that it's for a lawful business purpose, assuming, and I think as Matt mentioned before, there's probably some reasonable safeguards that we could put in place to ensure that folks have the ability to address any issues at the state level, and potentially also assuming that there's some upgradability, particularly for the algorithmic DAOs. If it's member managed, it's not really an issue. It goes off the rails, you know who's responsible, right? You point to those people, you bring them to court, you hold them responsible for what they're doing. That's something I would say we're pretty good at here in the US, bringing people into court. I think the trickier one is the algorithmic pieces. If that wants to be limited in a reasonable way, I think upgradability creates or at least soften some of those concerns without mandating that the government somehow get involved on a more granular level.
Mr. Mayor.
Yes, can you hear me? Sorry.
Yes.
Oh, great, wonderful. Yes, I wholeheartedly agree with Mr. Wright. Looking at this, you really do have to look at it as a separation between what happens in terms of governance at a statute level versus what is happening at a technology level in terms of implementation, because they're entirely different. And it is the case, and it is in fact, that you don't need a Wyoming based entity in order to write something that goes off the rails, right? Anybody can write software that'll go off the rails. You don't need an entity to do that. So what we have here is looking at control in terms of statute and entity and membership and organizational control at that level of a system architecture. I'm not sure if I'm still on there. Okay. So as I was saying, from an algorithmic standpoint, you're never really going to have full control over code. This is, a fact of life. We have bugs, they happen. So making that distinction in terms of knowing what you can manage or not is important. I'm not sure if I'm still on there, but.
Yeah, Brendan, we had you. We still have you.
Yeah, we heard you.
I don't think he can hear us now.
Can you hear us, Brendan?
All right, that creates a new challenge.
Okay.
Sorry.
Oh, there. Do you hear us, Brendan? It's because he took the buds out.
Can you hear us, Brendan?
Give us a thumbs up, Brendan, if you can hear us. Well, we heard you.
Yeah. All right.
Okay. All right. Other comments, working group committee. Senator Rothfuss.
Thanks, Mr. Chairman. I'd like to hear from the members of the committee if there's anything else that they see that we're missing. I'd like to hear from Representative Greer. I think this draft probably meets a lot of his early drafting guidance on how he wanted to see it roll out. I know that we're still going to try and put together some case studies to then work through with this draft as kind of the next meeting product. So we'll have an opportunity to look at that as well. But before we get to the UW students, is there anything else that the committee sees we're missing or any concerns from select committee members?
Representative Greer, do you have any thoughts?
Mr. Chairman, I'm actually, the structure of this was fine. I'm not seeing all the problems. I guess with Professor Wright is this, if we're going to do this and it has a benefit and people want to take advantage of the laws of the state of Wyoming, which that advantage is liability protection, to have a forum in which to resolve disputes, I would keep it relatively simple until other things, and this is nothing simple about this, but keep it that way until it proves itself out. Don't bite off any more than we can chew. And so looking at what's here achieves one of the balances that I wanted to make sure we were aware of, is don't mess up our current LLC statutes. Okay, and then we offer this other opportunity to be able to develop in this world. That's fine. We can see how that moves forward. Again, I still feel as if to go to Henning's comments on this. Okay, maybe those are that's the next evolution, and we'll have to see. That's fine. But if you expect to take advantage again of being a recognized entity, and you're recognized on several levels, there are obligations that come with that. There are costs that come with that. There are regulatory restrictions that come with it. And I don't want to lose sight of that. So those are my only comments. With what we've done so far, it's much more palatable than where the discussion started. So thank you.
Things are becoming palatable for Representative Greer. It's a positive thing.
Mr. Chairman, the only thing is that we've already gone longer today on this meeting than I have in 6 years chairing my committee over time. So just point that out.
We'll chalk it down as working hard late into the burning the midnight oil is what I hear.
Yeah, Mr. Chairman, I prefer just the word smarter, but that's okay.
Appreciate you. Representative Yin, you've been silent.
Mr. Chairman, yeah, on the Dow issue, I mean, I think that the amount of work being put into it has really been amazing, but unfortunately, it's when it comes to corporate structures, it's not one that I'm the strongest on. So I do lean heavily on Representative Greer's opinion here.
Chairman Rothfuss, what do you want to do with this, with your bill that's in draft form?
Mr. Chairman, I think we've done it. I think we've heard a significant amount of feedback. We know that there's revision coming that will address some of the concerns, and I think we need to take into consideration all of the concerns raised, and then we'll bring this one back to the next meeting, and hopefully we'll be able to have it in good enough form to pass it at that point.
You want an informal Representative Lindholm motion to move the bill forward to the next meeting?
We could. I don't know that we need it. I think
we just strangely took that one.
Yeah, it was good. It was
motion.
good times when we did it, but I in the interest of time, I think we're in fine shape, and we still need to hear from our UW students too. So
yes.
I'd like to give them an opportunity to weigh in, and then hopefully we can be done about 6:30 and let Representative Greer go.
Okay, Hunter, Todd, you guys are on.
Good evening.
Hi, Hunter. Welcome to the Select Committee on Blockchain. Go ahead and introduce yourself, and then please feel free to give us any comments on your one. We want to hear about your participation throughout, and then obviously if you've got some substantive comments on the draft that you worked on, we'd love to hear that too.
Thank you, Mr. Chairman. My name is Hunter Otterson, and I'm a JD MBA candidate at the University of Wyoming. I came here to testify in favor of the supplement to the Wyoming LLC Act that would give legal recognition to decentralized autonomous organizations. I was brought in through my professor, George Moxery, through Matt Kaufman. And I just wanted to say that since passing the 13 pieces of blockchain legislation last year, Wyoming has already become known as the Delaware of digital asset law. I believe that credit for that term goes to Caitlin Long. But Delaware's business-friendly laws has resulted in roughly half the members of the S&P 500 being incorporated in the state. That's led to a cottage industry of businesses, particularly within the legal industry, that serve the needs of these corporations. So speaking as an aspiring member of Wyoming's legal community, I believe this proposed supplement would create similar opportunities in Wyoming. I think making Wyoming the de facto home of DAOs would bring people, jobs, and revenue to the state, not just in the form of filing fees, but also in the form of an increased number of attorneys in courts to serve these organizations. DAOs are not without potential issues. I think there's still serious discussions that need to be had about how to protect investors from fraud and how to ensure that DAOs comply with federal securities regulations. I think, however, these issues mainly arise from the fact that the technology behind the smart contracts and DAOs is so young. And as blockchain technology becomes more widely used, these issues will be smoothed out over time. A great example of this is something that Mr. Dietrich just mentioned. He's working on a way to make smart contracts readable by humans. This would make it more difficult for bad actors to perpetrate fraud, which in turn would increase trust in smart contracts and by relation DAOs by those without a coding background. I think this is a great opportunity for the state of Wyoming to continue to lead the country in being the most welcoming state for blockchain-based companies. As Mr. Wright mentioned in his testimony, DAOs are already out there operating now, and this supplement gives Wyoming a chance to stay ahead of the curve. I also agree with Mr. Maher that there are a lot of questions to be answered, but they will be answered They're already being answered by people like Mr. Diedrich. And this draft legislation is a great start. Thank you for your time.
Awesome. Thanks, Mr. Otterson. And if I understood this piece of your testimony correctly, you said if we pass this bill, we'll have more lawyers in Wyoming, which means it's probably about time for the legislature to take a stance on the bar exam and reciprocity rules and making that all much harder to be admitted.
That could be one way to look at it. I know that nobody has ever said, we need more lawyers, but, as the state is changing and as our sources of revenue change, this wouldn't be a bad addition to throw into the pot.
More lawyers. You hear that, Representative Lindholm? We can actually do that without just getting rid of the licensure requirements.
Mr. Chairman, I do have a bill to fix that in my committee. It's no joke, and it's got the Department of Defense backing it, which scared the crap out of me. I'm not even sure if I'm for it anymore.
All right, looking forward to that one. Mr. Shaker.
Thank you, Mr. Chairman. I have a brief statement prepared, if I may read it.
Absolutely. Well, why don't you go ahead, Todd, and introduce yourself first, and then have
My name is Todd Shaker, and like my counterpart Hunter, I'm a third-year student at the University of Wyoming College of Law. I was brought into this project by Mr. Kaufman and our professor, Professor Moxery. And I absolutely agree with everything that's been said today. I think this is an absolutely tremendous opportunity for the state. And I think this could put us on par with Delaware. As the way Delaware is with corporations, I believe Wyoming can be the Delaware of DAOs in the future. And if I may, I prepared this, and actually a lot of it has already been gone over a little bit, but if I may read this, if you don't mind.
Please.
My name is Todd Shaker, and I'm a third-year law student at the University of Wyoming's College of Law. I'm here before you today to express my enthusiasm for the potential legislation that will recognize the use of decentralized autonomous organizations in Wyoming. If Wyoming were to pass this bill, we would become the first state to embrace this technology, and it may place us on the forefront of a new approach to conducting business. In the manner that Delaware is recognized as the hub of corporations, and South Dakota is known for hosting many credit card companies, Wyoming may become the base for DAOs. This, in my opinion, would benefit Wyoming in numerous ways, but today I would like to focus on two tangible benefits. To begin, as Delaware collects fees on every corporation formed within its borders, Wyoming would do the same with DAOs. While these fees may not be substantial in cost, they certainly may be significant individually when multiplied by a large number. Along with the fees that the state would collect, individuals that reside in Wyoming may register as agents for these companies that wish to establish DAOs in Wyoming. These fees would stay within the state, and as every company is required to have a Wyoming agent, this could become a profitable ancillary business for the citizens of our state. Another possibly more attractive result of the registration of DAOs in Wyoming would be with our legal system. As with Delaware and corporations, the real long-lasting benefit would be that our judicial system could become very well versed in the laws of DAOs. This would result in significant court fees, as our state would host future litigation in the realm of DAOs. Wyoming would need attorneys and a judicial system that would be highly competent in this complex litigation. This may lead to an increase in legal firms based within the state and further revenue for Wyoming. It is my personal view that there is a very limited downside in pursuing this opportunity further. It could only benefit Wyoming to become known as the authoritative state in establishing DAOs and litigating potential issues in the Web's 3.0 reiteration. Thank you, Mr. Chairman, for your time.
Thank you, Mr. Shaker. Any questions or comments for our College of Law students? Well, I just want to, you obviously been listening in, so I'm sure you've heard some of this, but on behalf of the committee, I want to thank you for participating in the process, and thank you for coming and testifying in front of the committee as well. I think that, I'm not terribly senior. I've been here for about 4 years now, and this is the first time I can recall seeing College of Law students testifying, and being in having come from the University of Wyoming College of Law myself, it's exciting to see students testifying on matters. Appreciate that. Senator Rothfuss.
Thank you, Mr. Chairman. That was all I was going to say as well, as we really appreciate the engagement. We hope you'll continue to help us to refine this legislation, work it through with our colleagues that have been working on it, and make this the best piece of legislation we can put together to accomplish the objectives that I think you've rightfully laid out for us.
Sounds like it's going to finally put us over the top. We were at this constant battle with Delaware, and our young lawyers young soon-to-be lawyers are convinced that the Dow just might be the secret sauce to get us there. Representative Greer.
Yeah, thank you, Mr. Chairman. Also, having more lawyers is not a bad thing. As a matter of fact, our state lacks, professionals, and I think that's a good thing. And I like the fact that you're looking to stay in Wyoming, and it is an honorable profession, one that I engaged in for 22 years, and helping people and helping build things is something to be very, very proud of, and don't ever let anybody tell you otherwise. Thank you.
Thanks, Representative Greer. And of good note, although this committee may appear to have quite a few lawyers in it, the legislature is also lacking in lawyers, barely into the double digits, believe it or not. So something else to think about in your future careers as well. Majority Floor Leader Dockstader.
Thank you, Mr. Co-Chair. Something you might want to think about at the right time along the way is to maybe have a news conference with our two co-chairs, our professor, and our two university representatives here. This is kind of breaking some big ground. We're tying the university in, and there's some very big things that have happened with this committee, and put it out in a news conference and kind of help people understand just the importance of just what's happened in Wyoming, tying in our university. This may be a big opportunity.
I love it. Ms. Long.
Thank you, Mr. Chairman and Senator Dockstader. The university did announce today the formation of the Blockchain Center, along with it's us, it's MIT, it's Stanford, it's Cornell, it's Columbia, it's the University of Texas, and then the other two state schools are Arizona State and University of Arkansas. So there are a dozen universities, and we're right there with them. And President Seidel has just embraced this. It's very much part of his tech forward philosophy. So something really, really special is happening. And there's a lot of private funding that's already been raised for that. So
yeah,
it's very true.
And that's great. And I'm just saying, Mr. Co-Chair, if I could follow up, please, mask up and hold a news conference. Let the world understand this.
I love it. As you read off the list of those universities, it didn't sound terribly prestigious until you said that University of Wyoming was involved. And now I'm very intrigued at that prestigious list. Anything else, folks? All right. 6:33. It's a record timing. So Senator Co-Chairman Rothfuss.
No, Mr. Chairman, I think we're in good shape. Obviously, we've got another meeting in about a month and a half. We should have time to work through the changes that we need to make and hopefully get digital identity finalized, or at least in good form, in the Dow legislation further refined. And we've got a few more topics that we'll be tackling, but good work today. I really appreciate all of the hard work of the committee, the public that is participating through subcommittee work and working group activities. And again, it's a great effort by a great group to provide some excellent legislation. So thanks everyone. And we look forward to continuing this engagement with all of you.
Yeah, appreciate everyone. We sent some bills out of the gates essentially, but we have far more bills to still process. So it sounds like between now and December, we'll be working hard to get those ready, and then that final meeting, we'll be seeing what our lift is as we go into the session. So appreciate everybody's work. Representative Lindholm.
Yeah, thank you, Mr. Chairman. I just wanted to say good luck to everybody tomorrow that's an elected official and on the ballot. Big day tomorrow. It's going to be big W's all around.
Yep. Good luck, everyone. Enjoy tomorrow.
All right. With that, we'll see y'all later.
Take care. Thanks, everyone.